Good morning. This is a special meeting of the Cameron County Commissioners Court. As we do all meetings, we will start with a brief moment of silence, followed by the Pledge of Allegiance to the U.S. flag and the Texas flag. And I'd ask that the Commissioners Court lead us in those two pledges. Please rise. Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
Thank you. Public comments? We're going to take...
No public comment? I got a public comment.
Go ahead.
Let me see where I can find it. Just like to take the opportunity to mention publicly on July the 15th, Monday, at 9:30 a.m., there's going to be a sign unveiling of I-69E at the interchange in Harlingen, Texas. The public is welcome. Everyone is invited. This is a historical time for Hidalgo and Cameron County both, because at 10:30 they're going to unveil the I-69C sign at the interchange in FAR. And then at 12 noon, there will be a program at the Mercedes Lifestock Showgrounds at the Francis Cooper Event Center, to which, again, elected officials and public are invited. I repeat again, it's a historical time for the Valley, having an interstate designated down here, 113.5 miles of interstate finally signed, and hopefully in the near future will connect us to the rest of the interstate system in the United States. So all are invited.
Thank you, Commissioner.
Especially those up here.
Especially. Just to give notice to the public, a few items that we will be taking out of order. After we approve consent, we need to take one item regarding a new commission that we need to establish so we can post that agenda, and that would be item item J, we will take out of order. Item H and I of the open part of the meeting will be discussed after executive session. On items on the consent, item E, I've been asked to table that item. Item J.
Which one?
Item E.
E.
Item J to pull out. Item P and Q to pull out. Item double C to pull out. And that is, and then also the presentation by TAC will also be taken out of order, and that will be done after we discuss item 3J.
Judge,
Yes.
item Y and item GG, can you pull out for discussion?
Did you say why?
Y.
Item I and GG,
Y,
Why? Why?
not GG.
yes, as
Oh,
well.
GG also?
Yes, sir.
And why?
Judge, one more comment before you continue with the meeting. Just
You got it,
another public announcement.
You got 1 minute left.
Okay, I only used two.
And I've got one too.
Los Fresnos Annex opened as of Monday. The downtown office of Cameron County is closed, and all of the operations are now at the Cameron County newly built annex next to Stars, or across the street from First National Bank. All of the county business is occurring there now. So for the sake of those that do require services in that area, it's a brand new building. We will have a ribbon cutting in the near future. They're going through their soft opening, making sure everything is operational, and we're waiting for the grass to get a little greener around there so we can do something. So,
Thank you, Commissioner.
I do have a public comment too, Judge.
Yes, sir.
Mr. Billy Joe Simpson passed away on Thursday of this last week. He was a tremendous community leader who accomplished a real difference in the world in which he lived. Billy Joe was elected to the board of directors of East Rio Hondo Water Supply Corporation on November 4th, 1975. He was formally elected president of the East Rio Hondo Water Supply Corporation on November 7th, 1978. He, along with the original founders of the corporation, established a water system constructed from the ground up with the help of farmers' home administration funding. Billy Joe and his wife, Martha Ann, held the original meetings and organized the required documents in their home. The first potable water to northern rural Cameron County residents was metered to customers' homes in the area north of Harlingen in October 1980. And basically, through his leadership, the system has grown from 327 meters in 1980 to 7,300 meters in 2013. He was a man that gave a lot to his community, and just wanted to mention he passed away this week, and we should honor him. Thank him for his service.
Judge, I also would like to extend our condolences to the Hakama family. Jared Hakama worked with Cameron County. His father, David Hakama, who was an attorney, very well respected in our community, passed away yesterday. And also the husband of our newly elected appellate judge, Nora Longoria Hakama. So at this point, we'd like to send our condolences to the family.
Thank you, Commissioner. Under consent, any other items that need to be taken out of order or discussed separately, other than the ones that I've already pulled out?
Move to approve the rest.
Moved by Commissioner Gatsa, second by Commissioner Hernandez to approve consent as presented. All in favor, signify by saying aye. Any opposed,
Aye.
carries. Item I, consideration and approval of interlocal cooperation agreements with the City of Los Fresnos. David, you pulled that one out?
No.
Item I?
No, he said why.
Okay, all right. All right, do I hear a motion to approve it just in case?
So moved.
Moved by
Second.
Commissioner Gatsa, second by Commissioner Hernandez. All in favor, signify by saying aye. Any opposed, carries. Item J, consideration and authorization to approve the new 60-month lease for copier. David, you want to address that? This is on the Constable Precinct 3 in the Rio Hondo office, and unless the court has changed the position, I thought we decided to basically close that office and just consolidate operations in San Benito.
Yes, sir, Judge Commissioners, Martha and I spoke about this yesterday, and I spoke to the constable. This is the issue, you're right. The constable has an office in San Benito now. Formerly, he was in Rio Hondo, and so the agenda item
Well,
is-
no, let's be clear. It's the constable in San Benito basically took over the Rio Hondo operations, right?
correct.
So the San Benito stayed in
Stayed.
San Benito, but we consolidated the offices to San Benito. Is that
Right,
correct?
yes.
So what is the need for having a copying machine in San Benito?
Not sure.
Okay. Well, who would know?
Well, I
Well,
know
we
that
need
I spoke with the constable, and he said that they use it as a substation and it's convenient for them. I said, I don't know if the convenience is worth $250 a month.
It's not, I don't think.
Okay?
I know that I spoke to the constable yesterday, and he indicated that he uses this, or he has been using this as a substation for his deputy constables to receive incident reports and to serve some of the constituents that come in from the Arroyo Colorado area and that region, so.
Is that
That's what
is that a functioning office? Are we? No. I mean, is it staffed? I mean, is it, or just whenever somebody goes and opens it up? Because we had agreed that when the precincts were consolidated, that it would shift operations. There was no discussion about a substation.
It's
For that.
only used when they're there. I mean, it's not like an open office.
And that's why this issue came up.
All right. What would y'all like to do? Do I hear a motion to not approve it? Or do y'all want to approve it?
I would, y'all's willingness to meet in such short notice, but that's the need for speed, is we're trying,
Right. I understand.
we're trying to do everything we can to access the dollars as quickly as we can, because if we lose these opportunities, those monies are just redistributed to other areas of the state or the country, and that doesn't benefit our three counties at all. And so I believe Hidalgo's working on the same thing on a parallel basis, and Webb's working on the same thing, just as as we're asking you to consider doing today, so,
Manny, I've got a question.
yes.
In regard to the indigent healthcare program that
Yes.
you operate for us.
Yes.
And do a great job. Does any of this impact any of those delivery of services that we have now ongoing?
No, and we've talked briefly about that. What our initial thought process is, Commissioner, is to certainly leave that model alone and in place as it is, so that there is no impact, certainly in a negative way, to what's being provided right now in Cameron
This is all
County.
additional funding, right?
That's exactly right. This is additional
Yeah,
funding.
but we were giving you those dollars so you could draw down other dollars.
That's right. Keeping in mind that the indigent care program is a separate entity and issue in regards to the affiliation agreement that we have with Cameron County, but
So
yes,
how
that's
does
correct.
that drawdown, what happens to that drawdown from the 8% that we give you? You know,
Right.
what happens to that?
Our hope is that obviously the county continues with that model intact as it is today, so that those funds are available for drawdown, because that applies towards our cap, Commissioner.
So
as it
that's
has all these
separate-
other
this
areas.
is separate
It won't
than this.
affect it.
This
Okay.
is in addition,
Okay.
as Commissioner Sanchez
And
referenced.
That's where I'm going.
Right.
I do notice that in the bill and written into the bill is the opportunity to subsidize indigent care programs also with these dollars.
Yes.
Is that possibly going to be looked at? Because at some point, you know, some of these folks that we service, and I think last year, for example, there were 8 people that capped out, that
Oh, right.
reached the maximum, and they had to delay delivery of services, in one case, from anywhere from 3 to 4 months before they could go back into the program. Will this help in any way, maybe bridge those gaps? Is that something that might be looked at?
I think the consideration at the onset would be to note that, in fact, these funds are actually based on the levels of uncompensated care that we've previously provided, which directly relates to indigent care in the county. Doesn't necessarily directly relate to our Indigent Healthcare Corporation that you're referencing, but that's the basic reason that our cap level is so high at Valley Baptist, for instance, because of those high levels of uncompensated care that we do. I'll tell you what we are looking at.
Excuse me, just if you'll explain how we lost UPL and uncompensated care and how this is a substitute, I think that'll probably answer the question.
Right, and this all stemmed from the old UPL program basically being dissolved by the government and creating this Medicaid 1115 waiver program. To some degree, I think the short answer is when we have our public hearing on the 18th, I'm probably going to defer to our CMS expert to make sure that we all are on good, clear understanding of where those funds can go. But I do think it's important to note again that in fact, the cap is based on the high levels of uncompensated care we've already previously provided. This is basically the makeup for the shortfall in reimbursement for that particular care. So from that perspective, on a daily basis, we're doing more for indigent care in Cameron County that's just reflected in our Indigent Healthcare Corporation, right? However, Commissioner, I think you bring up a really good point, because the second pool of money is for those transformational type of initiatives.
That's where I was going next.
What we're looking at is whether or not we can consider the indigent healthcare program as a potential DSRIP initiative, so that in fact you can maximize those dollars and you can expand upon the program, and you can address those situations where in fact some of the claimants or patients have hit their cap. And so we're certainly looking at that as a potential option. We don't have the answer today, but I promise you we'll have the answer for you guys by the 18th, so that it's clearly outlined as to what those monies can be used for.
Well, I think that you need to definitely consider that aspect of it, because, you know, folks that had no medical home have actually found one
Yes.
in the indigent care program. And it's pretty innovative in what's happened with that program for some of us that deal directly with some of these folks on a daily basis, to see, you know, the continuum of care for those that can continue and the difference that it makes in their outcomes.
Right.
And, you know, you need to look at, I don't know what the percentages on the 2 pods of money are. I mean, if it's, most of them is UC care or DSHA care, whatever it's
Right.
called. But, you know, if you could take in some of those folks and identify them as a transitional, new, innovative program, which it is.
Right.
Because I don't know of anybody else in the state of Texas doing what we're doing.
I agree with you, and I think
You
it
know,
has worked well, and I appreciate the kind comments.
It's worked really well from what I've seen, you know.
It has, and then the other thing is all the hospitals are now looking at potential DSRIP type initiatives, and the pool of money is distributed in such a way that at the onset of the waiver, it's a 5-year program, by the way, and the bill has a life existence that completely and directly correlates with the life of the waiver. So the waiver's supposed to end in 3 years, so the law will basically dissolve in 3 years. Up front, there's more money placed on the UC side of the pool, but that transitions over to the point where it's almost made even by year 5. And that's the concept, is they want us to look at transformational type initiatives that will change the way healthcare is delivered, and with the outcomes that you've described, which is being able to medically manage somebody up front before they have diabetes and the acute symptoms that are associated with diabetes, obesity, all those kind of things. And so along those lines, with our initiatives, we're going to sit down with Yvette and Pedro and the folks here in the county to go through our initiatives with them, but it's chronic disease management, it's health literacy initiatives. I'd love for us to look at different ways that we can help the rural population in Cameron County, maybe mobile mammography units or something, anything that will help, as Yvette just said a few minutes ago, help and benefit the health of our communities, helps us too. Because to some degree, a large degree, and this is relevant across our whole country, people come to us after they're sick. They come to our emergency rooms because they don't have a primary care doctor after they're sick. And a lot of times they're acutely ill. And so they come through the most expensive part of the hospital, which is the emergency room, to seek primary care treatment, but they're already too sick or very sick. And then the costs just escalate tremendously because of the stage of their illness. So all the hospitals have committed to seriously looking at those type of initiatives in an effort to obviously transform the way we're doing things, but help make our communities healthier.
I make a motion for creation of the county health care funding district pursuant to 288.002 of the Health and Safety Code.
Moved by Commissioner Sanchez, second by Commissioner Gatsa. Any further discussion? Do y'all need to say anything? He said it all?
They adopt the comments of Mr. Vela.
All right. All in favor, signify by saying aye.
Aye.
Any opposed, carries. Okay, Pete.
Judge, Commissioners Court, thank you very, very much for your time and attention.
Thank you, sir.
Thank you.
Have a good 4th.
We'll see you on the 5th.
See you on the 5th.
See you on the 5th.
Item 4A, presentation by TAC, Texas Association of Counties, regarding Cameron County's Workers' Compensation Program. How are you?
I'm headed to the island now to avoid the traffic so I can watch all the fireworks out there. That's amazing.
Please introduce yourself for the
I
record.
will.
I know everybody knows who you are, but still.
There you go. It's ready? Okay. Make sure it goes up. I'm Lori Wiggins. I'm with the Texas Association of Counties, and I have been privileged to be Cameron County's TAC field rep and your risk management consultant since 1990. The relationship with TAC goes back even further than that. The county has participated with TAC for your workers' comp since 1974. So we've all kind of grown up with this thing, except for Mr. V, because he was already grown up, so he's the only other one. I don't get to make this type of presentation very often. Why are we not up? So, there we go. All right. I don't get to.
Counties, what basically the providers such as Valley Baptist are accessing about $82 million. So you can see the variance over the life of the waiver would be enormous in our 3 counties. It's also important to note that there are 2 pools of money available in the 1115 waiver program, and I've mentioned system reform projects. Part of the pool relates to uncompensated care, and the other part of the pool relates to what's referenced as DSRIP, and those are transformational projects or initiatives that the hospitals can undertake that will transform the way we're delivering health care in our regions, in our counties, et cetera. And the government has allowed those programs to move forward and has allowed IGT dollars to be matched for the reimbursement or deferral of the costs associated with those type of programs. So in each county, you're going to have hospitals that have access to uncompensated care, depending on their level of uncompensated care they provide in Medicaid work, but also hospitals that are interested in creating these transformational type initiatives will have access to these dollars as well, if in fact this vehicle is created by the county. So 1623 creates a path to access those unclaimed federal dollars to our region, specifically to our county, by allowing for the collection of fees from private hospitals in our county, we'll be able to generate the local IGT funds necessary to draw down the federal dollars that have been assigned to our region, our counties, et cetera, for payments related to really what amounts to the staggering amounts of uncompensated care that we do along the border. I think it's important to note that when you're referencing this particular participation fund, we're talking about an assessment on the local hospital providers, mandatory assessment across the board uniformly to all the local hospital providers. Hence the reason HMC is here, and certainly the reasons that we've been talking to all of the other local hospital providers and have kept them right in the loop in regards to this bill and the creation of this participation fund. So what the 1623 does, it provides a mechanism for Cameron and Hidalgo and Webb counties to draw down their share of dollars under the waiver program for local projects and indigent care services. 2, the mechanism is referred to as a healthcare funding district. And so basically what we're asking the court to do is move forward, pull the trigger in regards to creating a vehicle that will allow us to access those waiver dollars, and that vehicle will be referenced as a healthcare funding district. And then obviously the funds that will be assessed will be placed in what's referred to as a local provider participation fund. Each district created in this manner is governed by a commission consisting of the Commissioners Court of that district. So that's important to note as well. So this will be, you'll be creating a brand new district. The court will be the members of that district as well. So you're in complete control of how the car drives after you build it today, which is important to note that y'all will absolutely always be in the loop and have the ability to direct the direction of this particular healthcare district. What the district would be responsible for is adopting administrative rules related to the district, establishing the relevant tax to the local hospital providers, and determine the timing of the assessment. And when I reference the relevant tax to the local providers, the bill, as you can see it, once you read it and digest it, basically outlines what that formula looks like, and there's a cap of up to 6% of the aggregate amount of net revenues associated with all of the local hospital providers based on 2010 data. And so the district would have the flexibility to create the tax and the level of tax as often as the district would want to meet. Our recommendation ultimately will probably be that the tax be assessed quarterly, so therefore it'd probably be wise for the district to meet quarterly to make sure that everybody's on the same page in regards to the assessment. Now, certain rules outlined in the bill include the criteria that the tax be uniformly applied, as I mentioned, to each local hospital provider, and as I just referenced at all, there's a particular cap on the amount that would be allowed. The bill also allows for payments of administrative costs absorbed by the county up to a certain amount to be paid by the county. In addition to that, if there's a cost associated with the tax assessor's involvement in this particular process, I believe there's a mechanism for the county to be reimbursed for those costs as well, or charged for those ordinary costs as well. And these are important notes. The bill specifically prohibits that any taxed amount be passed on to any patient. There's no fiscal implication for the state or for the county, for any of the municipalities where our hospitals sit. This is strictly and solely a tax on the local hospital providers. It is not a pass-through whatsoever. We also referenced in the bill that this is not an expansion of Medicaid. That was very relevant in Austin this past legislative session, but that's the reason that's very specifically spelled out in our bill as well. And there's also a lot of language in the bill that is based on requirements from CMS that in regards to making sure that at the end of the day this was going to pass CMS muster. And we believe it's appropriately worded, very well thought through, and in a real prime position for the county to move forward. So the next steps would be would include the creation of a healthcare funding district, which we're asking for today. This would be followed by the first meeting of the district in the public hearing to answer any additional questions or receive any and all comments from the county or local hospital providers.
Well, this would be for the Friday meeting, correct?
Yes.
Just to put the commissioners on notice that we will post a meeting for Friday morning at 10:30 a.m. here. I noticed when I posted the agenda, or when I signed the agenda this morning, Pete, though there was a public comment section. Mr. Vela just mentioned a public hearing. Would that qualify under the public comment, or do we have to post a separate item as a public hearing?
I would suggest, if we're going to follow the language in the bill, Judge, that you post a separate item as a public hearing, and that way all the
And we do
language-
this on Friday as well?
Yes.
Okay, Pete, we may have to adjust that agenda item.
The public hearing requires 10 days' notice, as I understand it.
I apologize, Judge, I misunderstood. If there's a public comment section for the meeting on Friday, I believe that's appropriate.
Yeah, that would be fine, but the public hearing
That's
is
correct.
got to be set down the road.
That's correct.
That's
And
fine.
so what we're looking at timeframe-wise, with the cooperation of the court, is to establish the first meeting for this coming Friday, at which point the new district would meet and set forth a order a public notice be given for a public hearing on July the 18th, Judge.
You all are under, well, we all are under a really tight time frame, correct?
Yes.
Say July the 18th is our next regular meeting.
Just 10 days.
Okay?
More than 10 days.
So we would have the public hearing at a county commissioners meeting or at this new board of commission meeting?
I would suggest, I would urge actually that it be in a separate meeting because
Correct.
this becomes a completely independent body associated with the county, obviously, but an independent body separate and apart from the Commissioners Court.
All right, we just need to make sure, because our meeting is at 8:30, so we need to make sure to allow for enough time to either we come back at noon or set it for 11 o'clock. So we want to keep that agenda item short if we can, so we can accommodate both meetings. Okay,
Or
Pete?
recess one and start the other meeting, and then come back.
We appreciate that. And the need for speed is this: the way the funding mechanism works with the federal government, they work on quarters. And what we understand to be the case for the first and second quarters of the government's fiscal year is they're going to require a transfer sometime by the end of July. Hence the need for speed to try to get our mechanism up and running on a parallel basis so the court will know we're very diligently working with all the other local hospital providers, with the county attorney's office, with Yvette, with Pedro, and everybody at the county to make sure that everybody's on the same page. This is going to be a very transparent process, but primarily that everybody's on the same page in regards to making sure that we get all the necessary documents in place, that the court feels comfortable, has knowledge, working knowledge of how the mechanism will actually work, all of those kind of good things. We'll have subject matter experts here available for the Commissioners Court on the 18th at the public hearing to answer any questions that the Commissioners Court might have. Our hope is by that time that we will have all of the documented pieces in place for the creation of the model.
Is there any concern from y'all's part whether we do it on the 17th or the 19th, or does it have to be on the 18th?
I think the only concern, Judge, would
Just
be
the 10-day rule?
the 10-day
So we could
rule.
do it on, I mean, I guess what I'm trying to avoid is that we're here for an 8-hour or 7-hour meeting, one Commissioner's Court for 3 or 4 hours, another meeting, we don't know if it may last an hour or two. We'll look at the agenda. I mean, we won't have it any earlier than the 18th. It'll be either the 18th or the 19th, which is a Friday at 8:30 or 9 a.m. Is that okay?
We will accommodate the court. We appreciate
Bail on overtime will probably be right at the budgeted amount. They have $160,000 left right now, $160,000 left. And if there's a shortage, it'll probably be about 10 or 15,000 short in overtime. They do have $244,000 in lapsed salaries in the jail. None of that money has been excuse me, designated for the housing of inmates. We do have a budget amendment when they come to court, for the next agenda item, where we're requesting to set aside some of that money to cover lapsed
Well-
salaries, but
How many vehicles is it, Martha?
4,
And if we're talking $12,000,
yes.
I make a motion to approve. That's a
Second.
cheap price to pay.
I just wanted to acknowledge.
So the rest is coming from the grant, right?
Yes.
Okay.
Moved by Commissioner Hernandez, second by Commissioner Sanchez. Discussion. Just real quick, Marta, on if y'all remember when we adopted the budget last year, we adopted no money for the housing of inmates. And I just don't know, $12,000 is not going to make or break this lapsed salary, but we just need to be aware as other departments come for different things that we keep a handle on what those lapsed salaries are going to be and what will be at the end of the year. It's always been the account that we use for emergency items, unbudgeted items, and I'm just concerned about the housing of the inmates. I don't know where we are with that.
Well,
So
and
let me ask you
that's why I asked about how much, we are in overtime, because that would be my big concern. But here, we're going to spend $12,000 to get, what, an $80,000
Yeah, no,
value?
it's not so much the dollars, it's more the theory behind it that I look at, and just in order to be consistent with how we spend those lapsed salaries. I'm sorry, go ahead.
Have we had to send any inmates out of the county?
We sent out, I believe right now we have about 20 female inmates out, and the cost for the month of June will be approximately about $15,000. I spoke to Mike Leonard as to an anticipation as to when we would be able to bring those back, and there was no indication that they would be coming back anytime soon. So we have a budget amendment to go to Commissioners Court for approval today, where we will be we're requesting the court to utilize $35,000 of the lab salaries that the jail has of the $244,000 that they have right now to cover June and July.
Okay.
These are not patrol cars, right?
I don't know, the chief is here and perhaps he can address that.
Oh, it says,
Oh, here's,
I'm sorry, they are?
okay.
They are patrol cars.
Yeah, so we're using 4x4s now as patrol cars? I know there's been an issue with 4x4s in speed and, you know, rollovers and things of that sort in the past with this court. And now we're requesting 4. Is that just out of curiosity? See, it's 4x4s is what I see here.
Definitely, because we work most of the time, we patrol out the outside rural areas, commissioners well know. We also patrol around the border, and that's one of the reasons that we were able to get these funds through the grant.
So
that
that's
we-
what that's for?
That's what it is for.
Okay. No
you
problem.
also patrol the beach, also on Boca Chica Beach?
By all means, absolutely. And out there, if you get stuck, I mean, this helps us a lot. Thank you for reminding.
Yes, sir.
Thank you.
And they have locking differentials.
Yeah.
Any further discussion? All those in favor, signify by saying, hold on, let me hear a motion. Somebody made a motion?
Yeah, it's already made.
Yeah.
Okay, all in favor, signify by saying aye.
Aye.
Opposed, item carries. Let's go to the item 4A, which is the presentation by, how long is the TAC presentation going to take? Because I want to make sure that we, you know what, let me go to the.
3J, because I need to post the agenda.
Yeah, let me go to that item. Let me go to 3J, consideration of possible creation of a county healthcare funding district. Hey, Manny. Okay, sure. Thank you, sir. How are you? And the reason that we brought this forward, we need to have another meeting on Friday in order to do this. And
Yesterday.
so we need to get this on so we can meet the 72-hour requirement.
Judge and Commissioners, this is part of the Medicaid changes that I talked about earlier. I would like to thank the Commissioners Court for their support in making Senate Bill 1623 happen. This is something that was very, very important to our area, and I also want to thank Manny Vela, and he took the leadership for our area also, and so I'm going to let him talk about this. Thank you.
Thank you.
Good morning, Judge, Commissioners. It's always good to be here with y'all, and we certainly appreciate the opportunity to visit with y'all about Senate Bill 1623. To start, I'd like to introduce Matt Stone, who's the Chief Operating Officer with Valley Baptist Health System. We have 2 representatives from Harlingen Medical Center here as well, Brenda Ivory and David Glassburn. They're sitting right next to Matt. And just for the court's knowledge, we certainly let every single hospital provider in Cameron County know of the meeting today, the agenda item, et cetera. What I'd like to do this morning is to basically cover with the court the steps that are outlined in Senate Bill 1623, which will result in, hopefully result in the creation of what's referenced as a local provider participation fund. But what I'd like to do just briefly, if I can, is sort of outline the need for the legislation, noting that, in fact, it was a hard fight getting this passed in Austin this legislative session, but we're certainly appreciative of all the efforts that our local elected officials made in regards to this bill, and certainly appreciate the governor signing off on this bill at the end of the session. I believe that the court's familiar with the old upper payment limit program that we've always referred to as the old UPL program here in Cameron County. And it's important to note that's a program that preceded the existing 1115 Medicaid waiver program that we're talking about this morning. That's a program that was utilized in, old UPL program is obviously the program that was utilized in Cameron County over the last several years, and they just recently transitioned into the 1115 waiver program. Now, as a reminder, access to the old UPL program and the existing 1115 waiver programs rely primarily on intergovernmental transfers. Commissioner Sanchez referenced IGTs a minute ago, and so that's what intergovernmental transfers relate to. IGTs are used to provide the state matching funds for federal payments that are available through this 1115 waiver program. Now, this works real well in other parts of the state and other regions because they either have public hospitals or hospital districts that create the IGT. However, in the 3 counties that are impacted by Senate Bill 1623, which are Hidalgo, Webb, and Cameron counties, we have no public hospitals, we have no hospital districts. Therefore, we still have the problem that we've always had about having lack of access to IGTs to access those matching federal dollars that are available to us or should be available to the local providers. But I think it's also important to know that this juncture that the amounts of dollars available to local providers through the waiver program is completely dependent on the amounts of uncompensated care and percentage of Medicaid care provided, and that the basis of those dollars available through the waiver represents shortfalls in payments received from the government for these type of services. Hospitals in each county, and this is important to note, hospitals in each county will have different levels of cap room available under the UC uncompensated care part of the waiver program. And this is directly related to the amount of unfunded care for services that we've provided previously based on uncompensated care and the high levels of Medicaid care that we provide. Our inability to access, and this is a real problem, and this is what prompted us to get up to Austin this last session. Our inability to access the additional IGT dollars could have resulted, or still could, if the county decides not to proceed with our vehicle this morning, could result in the hospital providers in the 3 counties that I previously referenced, leaving $540 million on the table that we would be unable to access. And as I referenced, this just relates to the local providers in the 3 counties, Cameron, Hidalgo, and Webb. Right now, just to understand the variance in the 3
I'd make a motion to table it until we get further information to make sure it's being used.
All right, I hear a motion to table by Commissioner Hernandez, second by Commissioner Benavides. Discussion? All those in favor, signify by saying aye. Aye. Any opposed, item carries. Item P, consideration and approval for Cameron County Department of Health and Human Services to participate with Tropical Texas Behavioral Health and provide mental health care. Is this are P and Q similar?
Yes, Judge.
Let's go ahead and address item Q as well. Yes, ma'am.
One is women and the other is children, right?
Yes, postpartum women and their families, and the second one is for children with, that are medically fragile and their family.
Okay, and who pulled it?
I believe Dilbia wanted us to let the court know that we were trying to work with Tropical Texas. If the court will recall, the Medicaid program changed last spring. There was a lot of information being disseminated, and basically the Medicaid program changed to 2 parts. One is a managed care program, uncompensated care, and another one was for the healthier communities, to try and come up with projects to have a healthier community. Because the county's public funds are tied into the indigent program, we sought another resource, which is Tropical Texas, and they agreed to provide the public funds so that we could establish a couple of programs that would help out the community. In our case, we have a maternity program, and so we wanted to have mental health care services for postpartum women who might be experiencing postpartum blues. And then the second program is we do have a Children's with Special Health Care Needs program, and that's children that are medically fragile. And so those families are often very stressed in financially and emotionally. And so we would like to have some counselors available to those families as well. And those are the two programs. Tropical Texas is putting up the funding to for basically this program would run the way our grants do, in the sense that these employees would be county employees, but the funding would come from Tropical Texas, and we would have to meet some performance measures.
Okay, so is there what is the action you want with us today? Because we don't have that grant proposal in front of us, the dollar amounts. the number of locations that these services would be provided at, or how many counselors we would be employing?
We just want permission to us to continue
To
to work
participate.
with Tropical Texas.
I'd move to
There
approve.
is a contract that is forthcoming, but we
Okay.
wanted to put this on the agenda first.
I just didn't see it on the, okay.
Move to approve P and Q.
I want to ask a question.
Okay.
How does this interact with Valley Baptist's treatment center? Or does it, or?
At this time, what we're focusing on is women who are in the maternity program within our,
Okay.
so some of the women do deliver at Valley Baptist, but if they continue to receive postpartum services at the county clinic, or whether they, as long as they were enrolled in maternity, then they would be able to access the counseling services by a counselor.
I'll second that motion.
Moved by Commissioner Sanchez, second by Commissioner Hernandez. Any further discussion?
Just to clarify a little bit, by getting into these programs, this money is considered what they call IGT money, and we will be able to draw down more funds, matching funds, by entering into these programs, and that's why the waiver program promotes this type of activity. So it's going to benefit us in drawing down more money, and it gives us the opportunity to serve more people in the community through the Tropical Texas dollars, not necessarily Cameron County dollars. So, I mean, I think for us, it's a win-win no matter how you cut it.
And we do hope to have a contract by July 18th at the next Commissioners Court.
Anything else? All in favor, signify by saying aye.
Aye.
Any opposed, carries. Item Y, consideration and authorization to accept up to 30 computers from Texas Health and Human Services Commission.
I requested this item be pulled so that, to make the court aware that there are costs that are not included in this, which will be the cost to bring the computers online and to get them serviceable. I spoke to Javier Mendez yesterday regarding a funding source, and the intent is to fund this from the parks. He does not have a cost data on that yet.
Okay, yeah, but how much can it be? I mean,
Microsoft Office per computer, right?
Joe gave me a quote this morning, it's $149 a computer.
yeah, it'd be less than, okay. You have funding within the park system to do that. Here, a motion to approve by Commissioner
Second.
Gatsa, second by Commissioner Hernandez. All in favor, signify by saying aye.
Aye.
Any opposed, item carries. Item double C, consideration authorization to execute amendment number 1 contract license agreement. This is related to the fireworks to include Friday and Saturdays on the beach from July 5th, 2013, October 26th. I asked that we approve this subject to GLO approval. Have we received GLO approval yet?
No, I spoke to them this morning, they said that they didn't see a problem with it, but they would get us a letter.
Something in writing?
Yes.
Okay, do I hear a motion to
Move
approve?
to approve.
Second.
By Commissioner Benavides, second by Commissioner Sanchez. Any discussion?
Question.
Thank you so much.
Question.
Yes, sir.
Have we addressed the parking issue, Javier? Or have
Parking issue with the...
parking issue with the parking, you know, I mean, I know we've got a couple of calls with parking problems at that end and things of that sort.
No, we met with Clayton and Barry, and we've looked at different sites where we can build some public parking for the hotel and for, of course, for other projects or other things that are going on in the island. You want to go ahead?
My name's Clayton Brashear, owner of Clayton's Beach Bar on South Padre Island. I just want to talk about the fireworks for a minute real quick. The fireworks has been a big hit. We had over 3,000 people out there this past Saturday night. We want to continue it Friday and Saturday night all the way to October. We've signed an agreement. Our payment to the county will be over $5,000 now for the parking, and we really think that it's free to the public, so we invite the county to come out and enjoy it, and I just want you all to see what we're doing out there. It's a great show on the beach, and it has drawn a lot of issues of parking to the area, and we discussed that would happen. We are drawing people to that area, and we would like to participate with you guys and help you guys, you know, get a parking area, another parking area in that area, and we're ready to do so. We're ready to move. You have a beautiful piece of property right there across the street from the Hilton, and we'd like to help you guys develop it, and, you know, let's let's bring some people to the beach.
Clayton, quick question. This addresses Friday and Saturday. Is Louis still going to be doing theirs on Fridays?
They are.
So they'll be doing simultaneous fireworks?
South Padron, the capital fireworks of the world.
So is that a yes?
That's a yes.
All right.
Is
okay.
the show at the same exact time, or they?
At the same time, the
It's,
area.
it's almost like surround sound.
The area is,
So,
whichever way you look at it. The area is getting congested, like Friday nights around Louis' backyard, so this might spread it out a little bit, but the beach has a lot more space to put people.
Right.
And you guys need to, start opening up that parking lot, and people are starting to congregate. People that are on the North Beach, Access 5, they're starting to come down to watch the fireworks. I mean, it's really a very interesting show. You guys need to come out, and Friday night we got Kevin Fowler, and we're gonna have a real concert out there. It's gonna be fun.
I think it's just fighting the lines back. It's an hour and a half wait on the causeway at times. It's just, parking's an issue, so.
Spend the night at the Hilton, the county makes money.
It's booked.
It's always booked.
It's booked on Friday.
Anyway, well,
Camp
thank you
out
for
on the beach.
Thank you for for doing that and bringing that to us. I just keep working on the parking issue as we go on. So, all right. Do I hear we had a motion and a second to approve? All in favor, signify by saying aye.
Aye.
Any opposed? Item carries. Thank you. Thanks, Clayton. Item double G, consideration authorization to purchase 4 replacement patrol vehicles utilizing the Caldwell Country Buy Board contract.
Should be county.
I read what it says.
I requested this item be pulled because they are requesting to use lap salaries, $12,000 of jail lap salaries. So if the court's intent is to do that, we need for y'all to acknowledge
Well,
that.
How are we on overtime?
The jail.
That's what we're looking to get.
We got to make the loan payment.
Well,
I've got a suggestion. For example, the sheriff and the jail division, and I think Mike and the sheriff are here. I know that, at some point we had discussed maybe that they would help us with this, but, there's probably close to $200,000 in that division. I would recommend to this court that we go to the lap salaries and just buy that, use lap salaries, and get all that equipment bought. They need to be, them and that office need to be
Right.
like, right.
They're the first line.
They're first in line. So if we have lap salaries that we can utilize to buy that equipment for them, let's do so. And let's get that piece off of the.
is that about 200,000?
Yes.
Well, that's why I mentioned a few minutes ago that agenda item on, that we really have to look closely at those lap salaries that we've got, so we don't, if we spend those monies now, then where are we going to get any money to pay for the housing of inmates?
If it happens.
Because we didn't budget, well, we've already got
No,
30,000 that,
No, I agree with you.
and this is what happened when we set up the budget at the beginning of the year. We didn't set aside any money for the housing of inmates, and figured this was going to happen, and here we are.
The downside of using current lap salaries that we have is that lap salaries will always serve as a backup for what we have cost overruns.
Cushion's gone.
We have cost overruns. We may have cost overruns with the fuel, with the indigent defense, the ad litem attorneys, medical costs that we need to pay. And that has always served, lap salary serves as a buffer. And if lap salaries
Well,
are
I'd
used
rather
right
borrow
now, then
less than not utilize lap salaries and be cognizant that we've got to keep those costs in line.
the potential, I agree, Commissioner. My function is to advise the court. The only downside of that is that you use lab salaries now, and if we have indigent defense costs, if we have healthcare autopsy costs that continue to increase, and we're unable to meet with the current budgeted funds that we have available that are excess, that's going to go away. And at the end of the year, it will be it'll be a reduction in the fund balance.
Martha, I don't remember seeing it, but do we still have a line item restricted fund balance of $500,000 or $300,000 for defense?
It's indigent defense. It's $500,000, yes.
It's still in there, right?
Yes.
And that's been there as long as I can remember. That's never been, or hasn't been utilized.
Right.
Correct?
Correct.
And that was set up some time back, and that was set up for what purpose?
It was set up to provide indigent defense for indigent defendants
Or a
for
big
cost
capital
overruns that
murder
we had.
case or something.
Yes.
Right,
The high
but,
cost cases.
But throughout the years, we've been able to fund those out of current operations.
Yes.
Is that correct?
Yes.
So we still have $500,000 in a restricted,
As a reserve.
as a reserve.
Yes,
In
in
our
fund
fund
balance.
balance, correct,
Yes.
that we have not used at
the
least
past-
in the last 10 years.
No.
When did we
Well,
set it up? Yeah, it's been there the
Well,
last.
actually, the $500,000 was set up as a reserve for judgments. So we
Correct.
would- I believe about 3, maybe 4 years ago, at one point, we had $1.5 million, and then the following year, we set up $500,000. So we have had $500,000 for the past 2 years at least, if not.
I think it's been longer, but anyway, but we set it up in anticipation of something happening in the coming budget year.
Correct.
Correct?
Yes.
Well, that coming budget year was at least 3 years ago.
Mm-hmm.
So we continue to set it up even though nothing has happened. So that's 500, I'm not suggesting going to that, but I would, unless you want to wait to use that for these unfunded things that come up. I mean, we've had 500,000 sitting there for at least 3 budget years.
Right.
Correct?
Yes.
And we may not need to use that. If y'all want to keep it there for the future, that's fine. But we've got $500,000 that's, well, we got
maybe
500,000.
To me, the future is today, because if we've got 500,000 we're not using.
Right.
You add it into the lab salaries
Uh-oh.
of whatever it is. and-
Whenever Javier gets up, he's always the bearer
I
of,
said,
of,
we're going to
of-
be,
of
we may
bad
be a little
news.
Sit
bit,
down, Javier.
we may be a little short this year.
Well, I mean,
Well-
you can't look at it, okay, we have this extra money sitting here. It's still your fund balance.
Correct.
So if you're using it, you're hitting your fund balance. As long as
Well,
you're aware
but,
that
but that fund balance is not part of our unrestricted
Right, it's not
fund balance.
unrestricted, but it
So we don't
is-
even count, I mean,
It's still fund
It's
balance?
still your fund balance.
No,
Well-
but it's there to be used
Well,
for
but-
something.
look, I think we need,
It's emergency money?
That's what it's supposed to be.
We
And
need-
if all else fails, you have this set aside
Okay.
for that specific
well, this is
purpose.
failing.
But,
Okay?
I mean, it's
No,
up to you.
but
it's-
look,
It's still, you're still hitting fund balance.
yeah, but look, you have, when folks are looking at our fund balance, they're not looking at what we've reserved out. They're looking at the unrestricted amount of fund balance. That is what is counted for when in terms of days of operations, not as what is reserved out. And all I'm saying is that that's been reserved, that we either put it back in our normal fund balance as unrestricted, or we leave it where it's at, or we utilize it, something like that. But all I'm saying is that I don't want people to misinterpret what was said, because that reserve amount, it does not go towards the days of operations that we have where we're trying to compute our 45 or 60 days. Because all we're using is the unrestricted amount, not what is set aside for inventories or set aside for, for this. I mean, that's a separate amount. And all I'm saying is that we've had it in there for at least 3 or 4 years that I can remember, and we set it up early on in '08 or '07 in anticipation of all these murder trials that were going to happen or something was going to happen. Well, those things didn't happen. In other words, we paid them out of
Well,
our
they did, but we
current
paid 'em as-
we paid them as we went.
Yeah, a couple of years ago, we actually wound up hitting it when they had the
Rubio?
The Rubio.
Rubio, and there was like
appeal.
3 or 4 that all in the same year.
But then it was
And after
replenished,
that,
though.
it's kinda- Right.
Right? It was replenished, so it was replenished through current year's activity or at the end of the year when we closed out. Okay, so I thought that when you all made the presentation about this equipment list, and maybe correct me if I'm wrong, I know the sheriff is here, but wasn't there an amount that the sheriff had committed or said he would help us fund this?
We were going to ask them if they could fund it.
Okay, it was about 100,000?
Yeah, about 100,000.
But I was under the impression that he had agreed to fund that, or nobody spoke to him about it.
No, we hadn't. It was a suggestion. We had discussed it, but of course, it needs to go through his approval
Correct.
first before we can
Now,
do
this
any of
was
that.
coming out from drug forfeiture funds, correct?
That was going to come out of the
Or the
commissary fund, I
commissary.
believe.
Okay. And has anyone spoken to the sheriff about utilizing some of this money from there?
Yes.
And he doesn't want to do that?
No.
Okay, all right. So then, we're still down to about 800,000 that we're short. So, the court want to, yeah, we got the 1,080,000 less the 150 that was the,
Okay.
right?
Right.
The 150 that it was from the jail operations or the sheriff's operations lapse salary, is that correct?
No. That was
No,
from
you're talking about the 150 from the CUC.
Oh, I'm sorry, you're right.
Council of
Calvert
Oregon
County.
Counties.
Now, how much do we have in lapse salaries that are coming out of this jail? How much do we have available that you feel comfortable taking out?
They had 244, and we used
35?
35,000
Okay, so
for-
about 200
to
little-
cover 2 months.
So we have about
A month and a half.
200,000?
Yes.
So we have, that's through what, through June?
But we still have August,
June and
September.
July. You still have August and September.
Okay, so we got 2 months left, and we spent 35. Would you want to earmark,
Another 35.
or let's say 50,000 for the last 2 months, and then take whatever is remaining from there and apply it to this? Can we do that? Would you feel comfortable with that?
We,
She
we
wouldn't,
can,
but
but.
she wouldn't advise it.
Well, but look, if you spent 35, we're setting aside 50 for the last 2 months. I mean,
You have to, well, 35 covers only mid-June and all of July.
Okay.
And presuming that the
So that's why I'm giving,
population
that's why I'm saying do
outstays at
50.
20.
That's why I'm doing 50. And that'll
The
cover 2
incident
months.
of crime amongst women is increasing.
I have no effort in that.
Well, but I mean, that's who we're shipping out is women, right?
Yes, the women.
We don't have enough room for them.
The women are outsourced.
We had one that gave birth in custody a couple weeks ago. My client.
Yes, sir. Hi, Sheriff, how are you?
Let me address the court. Okay, at one time, we said we would go ahead and pay about $30,000 or $37,000 for the equipment we need for the jail. But according to Mr. Bruce Hodges,
The interest payments of August the 15th. So we received that check back. That check was voided, but it will need to be processed to Bank of New York. However, Bank of New York has requested that we not send them the payment right now and to give them time to get all of the paperwork in place. So I would like for the court, since that payment is due by August the 15th, I would like the court to go ahead and approve the release of that check as soon as we get verification from Bank of New York that they are ready to accommodate the mechanism to receive the payment. I also have voids number 299-200. That check was misplaced. Void check number 303191. There is a name correction on that vendor. Void number 303154 and 303226. The employees are not traveling on the check, so they are being voided. And that is all that I have.
Do you recommend approval?
Yes, I do.
So moved.
Moved by Commissioner Benavides.
Second.
Second by Commissioner Gatsa to approve claims. Please note my abstention on the affidavits I'm about to provide to you. All in favor, signify by saying aye. Aye. Any opposed? Item carries. Item C, discussion and possible action regarding the IT equipment needs for various departments.
We also take up this item with item F. I believe it deals with the same. A couple of meetings
Let's
ago.
include item F.
F.
Let's include item F in our discussion as well, having to do with Odyssey equipment for the county and preparation for Odyssey future versions.
The last time we were here, we presented you all with a list, and you asked us to go ahead and make the proper arrangements to start purchasing some of the equipment that we already had funding for. Joe and our IT department's already done that. We've already, if you look at the equipment list that was given to you, everything that's in yellow has already been purchased. And I think we've spent about $129,988 to buy that equipment, and we have a pending balance of $1,079,542 left to purchase the equipment we need for Odyssey, as well as other items supporting Odyssey. The last Commissioners Court meeting, you all approved the
How did it
financial
go up so
institution.
much? We were at 700,000.
We had to, some of the costs associated with additional software and, servers that we needed to implement some of these other functions of Odyssey were a little higher than we initially anticipated, or were in addition to some of the items that we originally anticipated we needed. And that's the reason for the higher cost.
I don't think the equipment for the auditor and the tax office were included on our first conversation we had.
The initial conversation, no, but we did talk about it, it just wasn't
Yes.
included on the initial list.
That's why it's gone up, that's part of the reason? Correct, okay.
I had spoken to Civil Department, and I know that the Constable's Office has computer Odyssey needs of approximately $26,686. And the determination, based on an AG opinion and what we have been able to find, is that if the court makes a determination that purchasing, that the computer needs of the constable's offices will be to enhance and to complement the JP, Justice of the Peace, technological needs, and it will improve their improvements as well. It will enhance their function as well as constables serving the Justice of the Peaces, that the JP Technology Fund can be used for the constables' computer needs at this time.
So when it says ordered there, that means you found a funding source, right?
Yes, sir. It's either taken out of the JP Technology Fund or the courtroom technology fund.
Okay.
Which is, I think there was 116,000 in the court tech fund, and we've used about 15,000 in the JP tech fund.
And the constable issue is about $19,500 according to the list,
Yeah, about 19,498.
which can be
for
used with
computers.
the technology funds can be used.
Yes, I received information on that yesterday, and the cost, including the licenses, will be $26,686,000.
Can you use the JP fund for the constables though?
Yes, there's JP Opinion 560, which governs that, which states that in summary, that the JP Technology Fund can be used, provided that Commissioners Court makes a finding that usage of this fund will be, to serve the Justice of the Peaces. The summary is the JP Technology Fund may be used only for technological enhancements for the Justice Court and continuing education and training for JP judges and clerks regarding technological enhancements. Whether the purchase of a computer for a constable serves as a technological enhancement for the Justice Court is a fact question to be determined by Commissioners Court in the first instance. The fund may not be used to fund continuing education and training for constables.
Okay, so we have to make a finding that these computers are going to benefit the Justice Court.
That is correct, and that's what I would ask for the court to consider and to make that determination at this time. Juan, do you have something you would like to add on that?
The Attorney General opinion does make clear that upon a finding of fact by the Commissioner's Court that the technology to be used by the constables will enhance and complement the technological needs of the Justices of the Peace, it is appropriate to use those funds from the Technology Fund. It does require a factual determination. The Attorney General's opinion does not allow the use of the funds for training of the constables. But the hardware and with the changes with Odyssey and the upgrades to the system, certainly a determination by Commissioner's Court would be reasonable and rational, and it is allowed under the rationale of that opinion.
And that's if they're going to actually serve warrants and do all this stuff for the JP Court, right?
Yes, and the reason that they need these upgrades are for the Odyssey improvements upgrades.
Okay, Arnold,
Yes,
you ready?
I'm ready.
Yes, sir. How much money do we need? We got $1.1 million that we're short. Of that $1.1 million, let me rephrase that, not that we're short, but that we have to find a funding source, correct?
Correct.
Of the $1.1 million, how much can you identify right now that we have monies available? That we've got the money, in other words, I'm hearing the JP Technology, over here on the bottom left-hand corner, you have Court Tech Fund 116, JP Tech Fund 15, total 131, but then to the right you say expended.
Right. And those numbers there on the left are just, they're rounded figures. The actual expended was $129,988.
Is that the equipment purchase?
Right.
Okay, so then we're down to a balance of $1,079,000.
Right.
Of all this that we're talking about, and this is not a wish list, this is
No.
something that we actually have to have.
Yes.
In order to keep operating.
Correct.
So of the $1,079,000, where is it that we're going to go to help pay for this?
Well, Odyssey owes us money. Or not
we're-
Odyssey, but Council of Urban Governments, right?
And we're still working on that, yes.
Okay, what's that total?
284 is what we paid to them.
Okay.
284.
But we can't,
We can't count on that, can we?
I think we need to, I don't think that we can count on it for this purpose, but I think we need to look that we're going to receive that or a good chunk of that money.
yeah, I believe about a week ago, they sent a letter to the judge saying that they want to give us about 150,000 of that money, but they still want to meet. They want to meet and see if we can discuss that further. So that's what they put on the table right now, but
Okay, so we're starting off between 284 and 150. We have 150 that they've offered. They owe us 284, so it's going to be somewhere in beneath, somewhere there, right? So let's take 150,000 off of that for now.
okay.
Okay, so where's the other 800 and some odd thousand going to come from?
Well, that's what we, I believe you all approved the financial institution, so we can borrow the funds to make this purchase. I think you all approved that, was it last Commissioners Court meeting?
Of those, we're losing time, and I don't mean just short periods of time, I'm talking extended time off. And the committee and your elected officials, and I saw the sheriff here and Chief Reyna and all your other elected officials and department heads said, okay, let's do the return to work. Let's get people back to work. Let's keep them on the job because that's important. And there's a whole bunch of psychological stuff that goes along with that as well. But over 40 of your employees were losing major time. Okay, that was 2011. 2012, 270 claims, and of those, only 17 were now losing time. And this year, so far, 123 claims, only 7 losing time. That's amazing. That's really, really good. I wanted to ask Dahlia Salinas to come up and speak. Dahlia is your engineer. She is driving this train, and she's the one that is coordinating and working with these other safety officers, and I wanted to give her a moment to speak.
Good morning, Commissioners. Really, what I just want to say is I want to really thank all the safety officers out there, the supervisors, the managers, because without them, this wouldn't have been possible. We really brought our numbers down from the past years, and what we've been doing actively is going out there, doing trainings in the department, safety trainings. We're letting the employees know that our Cameron County's number one priority is safety. We want to return those employees home the way they came to work that morning, you know, as a whole. We're very, out there making them aware to be, taking care of each other, practicing safety, and just to be aware of their surroundings, of anything, and throughout these trainings, we have brought out that number has gone down so much. And like Lori said, back in 2011, as we were going through the numbers, from January through the end of June, we had 37 cases that were people that were losing time completely out of work of 7 days or more. And this year, as we were looking at it from January to the end of June, we've only had 7. And so, the numbers are going extremely down. So, but, it's not all me. I don't want to take all the credit. It's with the help with all the safety officers, managers, supervisors, because there are my eyes out there. They're the ones that are out there actively doing and practicing all that. I'll administer, I'll call them. The number one thing is communication. We have so much communication between each other, like for instance with Lupita Guerra from Public Works, with Laura Trevino from the Sheriff's Office. There's constant open communication there. If they need help with me, my doors are open. Constant communication with people from TAC also, in reference to people that are losing time and so forth. So, really, it's the employees out there and the supervisors and safety officers. Without them, the numbers couldn't have gone down. So, an applause for them.
Thank you, Dahlia.
Thank you.
Lori?
Thank you. I'm just going to scroll down because I want, maybe I should go the other way. Let's go, because I wanted to get everybody's name on the list, and I wanted to get that up there so that you could see that. That's really about all I've got, but I did want to tell you one other thing. With what, actually there's the Fabulous 51, that's what we've got. So Cameron County is ready for the next level of responsibility and the next level of funding on your comp. You're large enough to look at a self-funded option or maybe a high deductible program, because what you want is to have a stability. And y'all have that, and you have the communication, and most importantly, you have the infrastructure now to do that. A lot of people don't, and they jump off into something and they're not quite ready for it, but you're ready. You're ready, and I appreciate so much you all's support for giving us the opportunity, and the other elected officials and department heads for saying this is important, we're going to do this. So we're going to be working with your consultant, and are working with Mr. Wethy to bring some other options to you, because, like I said, y'all are ready. So thank y'all so much. I appreciate it.
Thank you, Lori.
Thank you.
Commentary? All right, do I hear a motion to acknowledge?
So moved.
Second.
By Commissioner Benavides, second by Commissioner Sanchez. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed, carries. Thank you.
Thank y'all.
And thank you to all the employees. Thank you for all your hard work and your dedication to the county. Budget amendments. Yes, Susie.
Just like to mention, we're going to have some cake and French coffee for everyone. He's welcome to join us with the coffee and cake for all the safety officers.
If it's still around, there goes Commissioner Sanchez right away.
I need coffee right about now.
No, I was going to say, you need cake right about now. Coffee's a byproduct. Budget amendments, line item transfers, salary schedules.
Judge Commissioners, as I mentioned earlier when we were addressing one of the items, the first budget amendment that you have, line item transfer, is where we're requesting the court approve to...
Can we have some light for some of us that are a little bit deficient in
Optically challenged.
illumination?
Optically impaired.
Challenged.
In other words, you're blind. I know.
Anyway, the first budget amendment is, line item transfer is to move $35,760 of lab salaries in the jail division to cover contractual expense, which we anticipate will be the housing for June and July. The next budget amendment is for the health department. That will start in September, and then all of the others are line item transfers, general and operational. You've got county clerk, civil division, the health grants, parks administration, county courts at law, JP 2-2, 3-1, M&O for the courthouse and for the Dancy building, constable's office, the extension office, and then from there on, they're all grant related. You've got HIDA grants, health grants, parks, and the bridges and beach safety grants as well.
What's that diesel for, the courthouse?
That is for the generator, the backup generator.
Has it been running? Or
The-
did we just not budget enough? Okay.
Those are the budget amendments and line item transfers. You have a number of salary schedules for the health department, then you have the juvenile department, and you have one for the DA's office as well for your approval.
Questions? Do I hear a motion to approve item 3A as presented?
So moved.
Moved by Commissioner Benavides, second by Commissioner Gatz. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Item carries. Claims.
Claims are warrants number 303468 through 303787, warrants number 303789 through 303979, warrants number 303985 through 304115, payroll for $1,728,573.58, ACH healthcare claims for $319,579.46. I'd like for the court to approve what will be, we anticipate being a manual check. As the court is aware, we had BBVA Compass that resigned as the paying agent for our 2005 and 2007 bond issuances. In the meantime, Bank of New York Mellon has been designated as the paying agent. We had processed the check payable to BBVA Compass, and that was for $460,598.76. BBVA Compass returned that check because they will not be the paying agent as of
Make this kind of presentation very often, but what has been accomplished and is being accomplished is, it's just pretty darn remarkable, and I want you to know. I want you to understand what it is. But to get to where we are today, I'm going to have to back up a little bit and give a little history and give a running start. And I'm going to try to be as succinct as I can because I know y'all are busy and y'all have got a lot going on. But gosh, this is a kind of a big deal. Workers' comp, you know, is not like any other insurance. Any other insurance, somebody has an auto claim, the adjuster comes out, he writes you a check, hands it to you, and you get your car fixed, and it's over. It's done. Claim's finished. Workers' comp's not like that. Workers' comp, some of the things that make it really, really interesting are lifetime medical. This means somebody has an accident today, we could be paying medical costs on that person, and you're responsible for medical costs for that injury, and we could be looking 50, 70 years down the road that someone is having to still seek medical attention because of an injury that they received here at Cameron County. The same with indemnity benefits, with income benefits. That can be lifetime. Actually, it can even go beyond lifetime. It could actually, because of surviving children and things like that, it could even go further than that. So we're looking at a tremendous long-term potential financial liability that goes along with workers' comp. Yes,
Quick
sir.
question.
Yes, sir.
In a workers' comp situation where you have a county employee that was operating a vehicle, which coverage kicks in first, the workers' comp or the liability on the vehicle?
Well, we would for example, if it was someone else, it was an at fault, someone else was at fault for the incident.
Right.
Workers' comp is always going to pay, but we will subrogate back against the other person's insurance.
So we couldn't do let's say we had uninsured motorist on our vehicle to cover that?
It's got to be workers' comp.
It has to be workers' comp.
Texas is the only state that says the only people that are required to have workers' comp are public entities, and that is the remedy for injured employees. So everything we do with workers' comp is very structured, and it's driven completely by workers' comp.
But for the employee, there's no election of remedy there?
No, it is workers' comp. That is the remedy.
Okay,
Yes,
so the employee that, let's say, got injured in the accident, rather than making a claim on the uninsured motorist for some personal injury protection and taking a lump sum payment, they couldn't do that as an election instead of filing a comp claim?
They could get their PIP, which is a no-fault, like a $5,000 limit. They could still get the PIP, but not anything else.
Right, but would that be considered an election of remedies, where then they wouldn't be able to come claim workers' comp on us?
Workers' comp is the remedy. Workers' comp is the remedy.
Okay.
Yeah, because you're, as a governmental entity, the legislature has been very clear since 1974, and that's why the public entities are the only ones in Texas required to provide workers' comp to their injured employees.
No, I understand that, but I'm
Okay.
talking about actually making the claim.
Right.
Because workers' comp doesn't kick in until the employee basically says, I got injured on the job, I'm making a claim.
No. Workers' comp kicks in when the county becomes aware that there has been an incident. The employee doesn't necessarily have to come say, I got hurt. They can, but it kicks in, and then workers' comp kicks in on the 8th day. So there is a 7-day period before workers' comp kicks in.
And that's what I'm talking about. Couldn't the employee, let's say it's a minor injury,
PIP.
right?
Yeah.
Say, you know what, rather than going through comp, I'd rather just get money from the insurance carrier.
No.
Okay.
Can't do it. Can't do it. It's got to be like this.
So then there would be no reason for us as a county to carry uninsured motorist coverage for any of our employees, since we have comp.
That's correct, and that's why your consultant just made that recommendation to you all.
Okay.
And we decided that there wasn't any reason to do that.
Thank you.
Sure. So, lifetime medical benefits, lifetime income benefits, there is a potential. So, for example, this year, with your workers' comp, we're not looking at this year's claims as you're funding this. You're not even looking at 2012 as we're funding this. We're looking even further back. We're looking at 2011, 2010, and 2009. So we're looking back to fund this because it's got such a long tail. You have to look back because there is history that leads into this. So it's very important. that you understand that the state sets a modifier. This is also highly regulated. The state says, okay, Cameron County, given your payroll and what it is that your employees do, this is your expected losses. This is what your losses should be to arrive at a 1. And that's what your modifier should be. Now, sometimes actual losses are below what is expected, and so your modifier would be a below a 1. But at the end of 2010, Susie Marfolino and Dahlia Salinas and I sat down and we determined Cameron County's experience modifier was a 1.99, which means, given one more point to get it to a 2, that means your claims are running 2 times what is expected for the frequency and severity of your claims. So you're running at a high modifier. And as a matter of fact, the year later, after that, your experience modifier went to a 2.13, which means that your claims are 2.13 times more than what is expected for your payroll and what it is that your employees do here. So we knew, and that's where I'm getting into why I'm here today, we knew that we needed to do something, and we knew what we needed to do. We did an in-depth analysis, we looked at it, and there's a lot of different factors that were driving this. And Cameron County, at that time, I would say, was no different than any other employer. It's a hard message, it's a hard thing to get the message down to the employees. You know, whether it's a big company or a small company or a big county, it doesn't matter. Sometimes you've got regulatory or statutory things, personnel policy change, whatever, and sometimes it's difficult to get that message down to all the employees. And we knew that we needed to get boots on the ground as far as out into your offices and into your departments to begin to deal with this issue and to begin to communicate to the employees what was going on. So Susie and Dahlia got their list of contacts together, and frankly, the first meeting that we had, I thought, okay, we're gonna have, 10 or 12 people. We had 50 of your employees who showed up, who care, and I'm gonna tell you, here's where Cameron County is different. The commitment and the dedication of these employees to do the right thing, they care about Cameron County, but what that looks like is they care about each other. And they are responsible for each other, and they hold each other accountable, and they take care of each other. And you know what you've got to do, but it's getting people to be committed to do it. And it didn't take a lot of urging, because your employees are those kinds of people. And I'm going to tell you, in 25 years of doing this job, I've never seen that level of dedication. And I think it's important that you know that, and that the citizens of Cameron County know it, and that the other employees know that, how effective this has been. Because not only is it saving lives and keeping people safe out there, it's saving some money too. And that is something that's going to be trending, again, because of the long tail, but we're getting there, and I wanted you to understand that too. So I call this committee the Fabulous 50 because they are pretty darn amazing. And I've got a few of them here today, and I wanted y'all to stand up, please. Come on. I've just got a handful. But I put the rest of the names up because I wanted you all to have that. Thank you all so much. And just to kind of give you some numbers to back this up, in 2011, right when we began this, we had 282 claims, and of those 40...
Our contribution can go either up or can go down on an annual basis. And so based on the returns that they're getting on their investments, plus additional employees coming in, our contribution is going up for next fiscal year. So based on that, that's just for the general fund. Software maintenance, there's additional maintenance agreements for Odyssey and other software programs. Currently, based on the expenditures for indigent defense, I have recommending an increase to that particular line item in the amount of $168,000. Autopsies.
Are we gaining any on software maintenance that we're not having to buy because we're not using other systems?
The only thing, because of the fact that, say, the district clerk, county clerks,
Right.
those were
They had-
in-house, done by the computer center.
All
We
of them were in-house? I thought we had
The only one that we were
contracts.
paying externally was for Hamer, what was it called? For the JPs.
Reflections was in-house.
Yeah, Reflections was done in-house by the computer center.
Okay.
And so we're just adding
So
maintenance.
none of the programs
No,
were contracted out?
no. Autopsies, it's, you know, the costs are increasing there. I'm not sure the status of if anything's going to be contracted with an individual or not. Individual maintenance and operations, we added, are those Fresnos because of the additional square footage. There's going to be increased maintenance. We purchased these 2 buildings, or 3 buildings across the street. I'm not sure what's going to happen there, but we went ahead and included some token dollar amount for something there. If
M&O
according for
and
maintenance
insurance.
operations, some electricity and some insurance, minimal, until something gets finalized with that. Our actual workman's comp premium for the general fund
So it
portion
could be a
actually-
lot more than 104 then?
It could be.
That's a very conservative number.
Yeah. Workman's comp premium actually is going down, and then there's also the removal of the park rangers from that, from the general fund. The only thing that I have right here, not included in the budget, and it's something that we'll be discussing, is the recommendation to actually increase the amount of funding for that the county contributes for the health insurance premium, the annual premium for employees, because that fund balance has been decreasing, and based on the expenditures, it's getting pretty low. And I know Mr. Wethy was here and made a presentation as to the cost and the healthcare costs increasing. And so we'll be discussing that more so as we progress. The Road and Bridge Fund, total, there is a slight increase there, and that has to do with auto sales. Within the expenditures, you can't see it there, I listed it on the bottom. Because of the lease payments, they're actually, since we didn't add any equipment to Road and Bridge Fund last fiscal year, payments dropped off, and so there was an additional $350,000 available within the Road and Bridge Fund, and so I shifted that over to road materials. So currently within road materials, there's an increase of $471,000 recommended for next fiscal year. What we'd like direction from the court is, I mean, as you see, just with the positions and salaries, I don't know, and I'm sure the court, until we get farther along as far as the revenues, as far as additional positions or salary increases for employees. I attached the list for the new position requests and increases. I don't know if the court wants to have individual or workshops and scheduling any individual departments to make any kind of presentations, or if we want to do that or not, or if the court wants to do that or not, or just as part of the general discussions, if they just come up and speak their mind to the court or not. How y'all want to handle that process this year?
It'll be a short conversation. Let me, Javier, real quick.
Javier and Martha.
Let me go back to the not included in budget on the health premium for employee of
Right.
$400. The reason for that is to replenish
the fund. Yeah,
the fund balance.
We've hit the fund balance the last 2 years in a row.
Right.
And so it's down to 1.7
Right,
million.
and we need to get it back up again so we don't get into the jam back
We
when.
were at 3 million when.
Right,
we
right.
started this.
Right,
Been
okay.
robbing Peter to pay Paul.
Correct.
Well, in essence,
Pay Peter back.
it helped balance the budget last time, and we don't need it, but now it's time to go back to where we
something
were,
we need to look at.
so we don't end up in a deficit like we were 8 years ago or 7 years ago. Okay, just real quick on the new position request, the one that sticks out is the probate courts, and I see that each county court at law is asking for a full staff to do probate. We had talked about that when the new probate court was not approved at the legislative level. Is that what, your number one? Or what?
all agreed to fund one court.
That's correct. We agreed to, that we would fund one court,
Fund one staff for probate.
yeah, one court for probate to be used as rovers. And that was what we had talked about back then. So now all of them are asking for full staffing?
That was what was submitted in their budget request
Right,
packet.
correct,
Right.
correct.
Is that enough to pay an auditor, though, Martha?
It's a little bit higher than entry level,
Entry level.
45,000.
So, I mean,
It's an entry level
we would be
auditor.
able to get someone for that?
You're presuming that that would be minimal audits that would have to be performed, or accountings.
And I'd like to clarify, actually, there's a typo there. The $40,000 position should be should be an investigator, not an auditor. It's not two auditors for each. It's an auditor and an investigator.
Well, but the
Same number.
salary's the same,
Yeah,
okay.
correct.
Well, bottom line, though, is that we had agreed to do that, so you may want to get with the judges and let them know that, in all likelihood, that's probably what we're going to do, just fund
Fund it
one
for one-
court
one
and then have them
individual
be a rover and just do that, I mean.
Yeah.
All right? So I would take two of those out right off the bat. And then on the other stuff we can talk about as we go along. On the salary increases, I think a little premature until we decide where we are with the budget. I would like to incorporate, go ahead and throw it in there, the scenarios of giving $1,000 across the board, $750 and $500 to all county employees, and just see where that's going to put our budget. Okay?
Okay.
Speaking of salary increases, one thing that I did want to touch briefly on is you have a sheet like this in front of you that was placed. And what that shows is in Senate bill that was, in the General Appropriations Act that was signed, you have the effect of the district judges that were previously paid by the state at 125. And in the appropriations bill, they went up to 140,000. So, and this takes effect September 1st of this year. So what you're actually seeing, the effect that the county will see is that the county court law judges' salaries have to be within $1,000 of what the district judges are getting, okay? So right now, your court at laws are getting 139 from all sources, and your district judges were getting 140. Come September 1st, the district judges will be at 140 from the state, and the county supplements 15,000. So we're going to see an effect.
What were we getting from the state before?
And no, they pay directly,
140.
125,000.
125, it's going to 140.
So it's
going to
going
140.
15,000 higher.
Right,
So
at
we're going to have to
150.
come up with another 45,000.
Yeah, so what you will see is that the court at law judges come September 1st will actually get a 15,000 increase per annum, but it will only be for the month of September, and the cost to the county of that will be approximately $4,200 because they have to stay within $1,000 range of what the district
So
judges
really
are
what
making.
affects, okay, right now, the way it is, what would affect general fund?
I would think that if the court approves approximately about $950,000 in equipment financing, then we could go ahead and move forward with this.
Now, we're not stuck to that number.
That's too
gentlemen.
much.
Yeah,
Up to.
Up to.
You know, I think if we approve financing, we won't look for money. And I think we ought to look for money before we approve financing. And I think we ought to look at lab salaries. I think we ought to look, I mean, it's uncomfortable one way or the other. And it's kind of like buying gas but not buying food. You don't need a car if you're not alive. So what does it matter where the money comes from? If it's lab salaries and there's $500,000 in that fund that we haven't touched in 3 years or barely touched in 3 years. Give me a break, guys. There's money out there. We can't be all comfortable all the time.
I don't think we have been.
Well,
I think it's
we've
been pretty
got
darn tight.
$500,000 that we've had in a fund that we haven't used in 3 years, except for maybe 30,000 1 year.
Then make the motion to do that.
At least take half of it.
Well, let's do this. Why don't we, look, I agree.
I'd rather look at all the little pieces before we make a
Right.
decision today, have a meeting in 7 days, and let's, I'll commit to visiting with you on the numbers and see what we
Okay,
can
well,
find.
we're gonna meet on Friday. Can you all have numbers for us by Friday? Because I realize you all have, I'm sorry?
Yeah, but we can set a meeting up.
Well, but
You
what
you
time?
could set up a meeting.
You all are on a timeline, so we
We
gotta
have to
move
do it
fast.
after 11 a.m.
It's 10:45.
You could set a meeting, and we would have the
The
lab
meeting on, the
salaries
meeting on
and all
Friday
that number.
shouldn't take longer than 15 to 20
No,
minutes.
but a 3-day notice.
No, I know. I mean, we still have time to do it right now if we post like for 11 o'clock, 11:30. I think we can do that.
I think the biggest concern, we expedite the
What-
purchase of this
Pete,
equipment.
why don't we do that? Let's
be at
post
spring break.
Another meeting.
yeah, let's post a special meeting
11
for
o'clock. 11?
Friday at 11:15, just in
Okay.
case we run
And-
over.
and
for-
in the
for-
mean-
For this item only. I don't want to, you know, just for this item only.
So for Fridays, we would give you a lab salaries countywide in general fund
Yeah, I think, I want to see,
By line, by department.
by department.
yeah, the lab salaries, I think you need to throw in there, just, we don't have to use it, but say, this is what's available in this $500,000 reserve fund that we haven't used. By that
What's the
time,
balance of that fund, too?
it's 500,000. Yeah, it's 500,000 in that fund.
Yes.
And then there you're gonna factor out, Arnold, get with CUC again and tell them that, you know, we need to have the money.
And then worry about it later.
We need to have the money. So, but for now, we're gonna book 150. We have the commissary funds that we're gonna use of 37. And then let's see what's left over. Okay? So you have that by Friday, all right?
Okay.
And Pete, you're gonna post. All right. Do I hear a motion to table?
So moved.
Moved by Commissioner Gatsa. Second. By
Second.
Commissioner Sanchez. All in favor, signify by saying aye.
Aye.
Any opposed? Item carries. This is for item C and F, correct? We tabled item C and F.
Yes.
So which one is more important, IT or auditor?
Auditor.
Huh?
Auditor.
Joe? IT, right? Martha, auditor.
Joe is beside himself. I don't think he's ever had an opportunity to get so much equipment all at one time.
That's why he,
I know, right?
that's why he wore the white shirt today,
I
man.
know.
All right. Item D,
The lifespan of this thing.
fiscal year 2013-2014 budget. This is item D. Oh, yeah.
Judge and Commissioners, emailed out, well, it's before you also, I also placed it before you. And what we want to talk about today is just a general overview, the beginning of this process, as far as the discussions with the court. This is where we're starting out. Of course, as always, the final recommendations still haven't been done, still reviewing the requests from the individual departments, looking at the requested increases on specific line items, and looking at the justifications for that. In this, what you have before you, the revenues are the same as they were approved for this fiscal year. They're currently being reviewed. The final recommendations for next year's revenues are pending. They'll be forthcoming later on. I also included, what I've received so far as far as requests for new positions from several departments.
Why would you do that, Javier? I mean,
Well,
because is this for next year's budget or this year's budget?
this is for 2014.
Next year.
Okay, next year's budget.
Yeah, correct.
Okay.
Yeah. So that's new position requests and also salary increase requests for various departments, just so that you're aware of what's out there.
And you'll get more of both
Probably,
between now and,
before it's all said and done. I'm going to start with the general fund. As I mentioned, the revenues are the same. Within the expenditures, have been going through the various line items within various departments, and based on current expenditures and contracts that have been entered into for this year, and looking at some operational costs. There are some, there's both increases and decreases in various line items, and so the net effect here is what's here at this current point. There is an increase in recommended expenditures of just over $450,000. There were some decreases that offset that, so the total is actually higher than that. The transfers, there's a decrease, but that's because of the park rangers are now back within the park system, so that's being paid out of there. There's a reduction there.
So it's a wash, basically?
It's a wash.
Okay.
Excuse me, transfers out at this current point is the same. So right now, as it stands, we're looking at a $966,000 shortfall. Below that is what is large dollar amount items that are within the expenditures, and also the transfer of what's there. Now, we were speaking about a little while ago, as far as the DA's office and that $200,000. If you'll recall, that wasn't part of the original budget. It actually got amended right afterwards. What we had originally adopted, there was a reduction of $200,000 to the DA's budget within salaries. Afterwards, we got a commitment from the DA's office of the $200,000 transfer, and so it was amended. Right now, our office is not 100% sure if that commitment is still there for this next year or not as far as the transfer. The positions that are there are still, though, within the expenditures. So that $200,000 is not into this $966,000 shortfall. If that transfer is coming, then that turns into $766,000 shortfall. So until we, get a commitment as far as the revenues, it's not going to be included. But the salary portion is still within the DA's office unless we get direction to remove that. Of course, there's been an increase in communications among several departments because of switching over to T1 lines and what have you for all the various county buildings. Retirement actually costs went up or is going up for this next fiscal year. Radio maintenance, y'all took action on that last week or week before or the last meeting.
What is the retirement cost? What do you mean by that?
That's what the county contributes to the retirement pool. And that's based on the rates that we get based on TCDRS. The county contributes to each.
Right, I'm aware of
match.
that, but why would it, is that because of more employees or more payroll or what?
Well, it's a combination of things. It's a combination of
because the
more
rate
employees.
is the same.
Well, the rate is of what we receive is the same, but see, their projections are based on their investments in the pool and what they project that we're going to have to pay out. And so because of that...
we have to go out and borrow. That's what we're trying to do, correct?
Right.
So we're down to about 700,000 or 800,000 from the 1.1, right? Okay.
I think going to lap salaries in the long term between now and September 30th is going to be a mistake. Because at the end of the year, we're going to come up short somewhere. And I think we need to get a report from Martha before we make a decision just to do that. Do you have any idea where we're going to be? Did we have that much fluff in this budget that we're able to take $1 million of?
We have.
I don't think we did.
Right now, the last time we swept lap salaries was probably about two and a half months ago, and what we have set up in the contingency is $57,000 right now in lap salaries.
Look,
The next item is...
When we adopted the budget and we adopted all the salaries, the reason lap salaries occur is because either the positions aren't filled for an extended period of time or the slot doesn't pay. So it wasn't like, I thought the budget was short by virtue that we did not fund some of these things. And we're not going to know that until the end of the year. The way that you take care of that is you eliminate positions. That's how you're not going to have lap salaries and you reduce the budget. But no one was willing to give up positions at the time. And I think the position was also that if there's a position that has remained unfilled for X amount of time, then that position would be eliminated because obviously they've operated without it for 6 months or 9 months. And
they've made due.
Yeah, they've made due. So why continue funding a slot that's not going to be there? Or that's not being filled. But anyway, okay, so are you going to come back to us on the 18th again with a revised list? By that time, you would have, hopefully the sheriff is going to come to us with something. I'm talking about just funding. We have a list, but the amount of monies that are available. Because then by that time, I would have spoken to the DA and see what is it that he can do.
Well, the only thing that, what you're running into is these are improvements and upgrades that are needed at this time, and I think this has been told to the court before. I know that from the auditor's standpoint, we have the software upgrade that we have come to the court with that y'all have considered and approved before. And there is a business process review that we have to go through, before the upgrade actually starts, and that's going to take about 60 to 90 days for the vendor to come in and do the review process with all the departments that use the system. And at the same time, we're going to run into our county fiscal year end, and we're going to have 6 months to deal with doing a transition to a new software system and to get our financial statement out. And we're going to be pushing it already as it is. So from our standpoint, we need to move forward with this.
Well, what did you anticipate us doing with this today? What?
Fund it.
What I had anticipated, what I had
Fund
anticipated
balance.
was the court designating a funding source. This is what we have. This is what we're going to use. We're going to use equipment financing, and because
Well, yeah, but we need to be able, my idea is we need to use any monies that are available now to pay what we can, and then look at the equipment financing as the balance of what we need to do.
That's what we did.
See, because this is a problem that's culminated over the years, right, Joe? Correct me if I'm wrong. In other words, because we didn't budget in the past to upgrade all this equipment, now we're getting hit with it for two reasons. One, because we hadn't done upgrades, and two, because of the new software. So now we don't have a choice. It's do it. So, I mean, if fund balance it is, I mean, it may be having to do that.
And the issue with Odyssey is that at the end in August, I believe, or September, we're going to roll out with a new version of Odyssey, and the sheriff's office and the jail won't be able to utilize the system adequately without this equipment in place. So,
right.
And then of course we're going to have to comply with the e-files mandate from the Supreme Court by July of next year.
District clerk's office.
Right, the district clerk's office. So we need to put everything in place as soon as we can, so we can start preparing and moving forward. Without the servers that we need to do this, I mean, we need these things.
We don't have a choice. We have to.
We don't have a choice. And the last time we were here, we talked about utilizing what we had funding for now, and then whatever we didn't, we were going to use equipment financing to make those purchases. So we went ahead and used the JP Tech Fund and the Courtroom Tech Fund, because those are the funding that we had then. We tried to use Fund 90, of course, she mentioned with the DA, we weren't able to do that. So we tried our other avenues. This is where we're at now, and this is what we need to move forward.
Well, let's get to the next agenda item.
Yeah, just real quick on this before we go through. This is just part, and Marta, this is part of the equipment list. There's still a bunch of other stuff out there that's coming down, isn't it, on equipment needs?
Yeah,
Right.
Okay.
Yeah, those requests won't even go out till October, November to the departments.
More bad news.
Okay, let us know what it is that you're
No,
going to be
the others
requesting.
is routine.
Every year.
Well, I think what we've always tried to maintain is as we reduce debt, we add debt so we don't have to increase our debt service.
Right.
That's what we've been trying to do over the last several years. And Joe, I know that you've come to us for years about it and, didn't do it because it was a budgetary issue, and it's going to be the same thing again. All right, so then on this one, what do you want to do, guys?
I think we should suggest some type of equipment financing. Since we're going into the budget process anyway, Martha, we look at the whole package and you work out how we can do it, what we have to set the rates at, the tax rates we have to cut, or whatever. But at least we put this in motion. If we don't put this in motion now, we're going to keep dragging and trying to come up with ideas how we're going to fix this. I don't believe we should go to lap salaries and try to use up all our reserves, because if we do, we're going to have a budget issue come the end of August, early September. We're going to be short. We hope not, but it could happen. But we don't know all those numbers yet.
The problem with equipment financing, and you tell me, Joe, what is the lifespan of this equipment, and what is the financing lifespan of the equipment?
Yeah, the financing, we have it set up normally for 3 years. What was different would be like the heavy equipment. At times, we would do that for 7 years. But for the computers,
So
vehicles,
3 years
whatever, it's
is,
3 years.
okay, and that should last 3 years.
Oh, yes.
Okay, all right.
I think what we tried to do was amortize the debt with the anticipated lifespan of the equipment, so, yeah. All right, so then, Marta?
And one thing, by moving forward with this through an equipment financing agreement, then this would allow the purchases to get done in this fiscal year And we would be able to consider the debt payments in fiscal year 14, and we would set them up in the budget as we're
Okay,
working
well,
the
have you-
budget
has-
for fiscal year 14.
Having this discussion, what is the number that you're going to go out right now? I think you can take the amount from the jail, from the lapsed salaries. I think you can take, I'm going to try talking to the DA about that $36,000. Good luck. And then,
Well, the other thing too, Judge, is at
So
the
how
end
much?
of the fiscal year, whatever we haven't used, we can designate to go pay off this debt.
something else. Okay, so how much do you want to go out for right now? Is it the 900,000, 943,000?
I haven't.
I don't want to go into debt.
I don't either. I mean, I just,
The total is 950, and
that is taking
it'd
out
be
what, though?
950 less the 37 for the jail, and 200,000 from lab salaries, and have you deducted the 27,000 from the JP Technology for the constables?
I haven't deducted
You need to
anything.
make
I'm
that
just trying to
determination.
figure out how much,
We
you
have
know,
to
we
make
need.
a
we need to-
finding.
Yeah, we
Right,
need to
right.
go do.
So the
I
difference
just-
is what you should go out for equipment financing.
All right, well, how much is that? I mean, I don't want to go,
Hey, well, some of these constables' office have Fund 90 also money.
I believe there's only one that does have it.
Only one?
Right.
Maybe we can ask them for some
Well, but you could also use the,
participation.
Well, but the constables, we've already
JP
determined that the
Technology.
JP Technology Fund will fund that,
correct.
okay? All we need to do is find
Make an official finding.
make a finding. That's like $19,000.
So there's enough in there to cover all of that?
$1 million, Pete?
no.
How about bail
I-
bonds? Do
We're
they
way
have-
down below $1 million. We should be closer to 600,000.
Are you taking lab salaries?
A little bit.
Why?
I say we
It's
should
gonna be-
look.
Yeah.
RMA have any money, Pete?
Said we couldn't, so we put a stop to it. No.
Well, that was from commissary?
Well, why don't you ask Juan instead of Bruce?
That's a great idea, and I will talk to him later, and I can come up with an answer for you all.
Okay,
We revisited that here recently, and there was some discussion with TCJS as to whether or not they considered, this to be a technological improvement for purposes of the statute, and they've said orally at least that they do. And since they are sort of the ones that set policy for jails, we've reconsidered that, and I let everybody know that.
So then what,
Yeah, Pete and I were on a conference call with Brandon Wood, and he says it would go towards the safety of the inmates. And based on the conversation that we had and what we told him what we were doing, he said that it would be an allowable cost to go ahead and use those funds.
which was how much? Was it 35
37.
that we can use from commissary? Are y'all willing, can y'all do?
We need that real bad. That's fingerprints and mugshots.
So is that yes?
Yes, sir.
Okay, so then we get 37,000.
Talk to Juan, okay?
37,000 out of the commissary. Is there anything that we can use, Sheriff? And I know that we always hit you for the use of your Fund 90 money, but either we get it from what we have, or we're gonna have to go out and borrow this money, and that's just more cost to us. Is there anything that we can count on the Sheriff's Office to use drug forfeiture monies on this? Is there anything that's allowable that we can use with this?
Judge, as I mentioned before, some of that money is very limited as to how I can use it.
Right, that's
okay?
what I'm asking.
And
If it's allowed,
If it's allowed, I'll let you know, but at the present time, I'm going to say no, okay?
Okay,
So I
that's
will
fine.
not get into myself into any kind of commitment.
okay, can you let us know in the next week or so? 10 days?
Yes, I will.
Okay,
I'll
just
let
us
you know whether we can
If
or
it's
not.
allowable, I think that's a two-step. One, if it's allowable. If it's not, it's a moot point. But if it's yes, then come back and see, look, this is what I think we can do that doesn't affect our future operational needs. Can we do that?
We can do that. See, I'm afraid that kind of program is going to run out one of these days, okay? And I'm just trying to have a little money set aside, because every time we come out here, the court doesn't give us anything. For example, we haven't any personnel for the last, since 1997 when I was here, maybe 4 officers, and I'm paying 13 officers out of Fund 90 at the present time. So it takes a lot of money plus everything else.
Has anyone ever done the math in terms of, from y'all's offices, how much drug forfeiture money you have at this point? What how much of it it's funding right now and what lifespan that would have? Has anyone ever done the math?
Well, I have done it, but I don't have it with me at the present time, okay? We're probably spending about $1 million that we help the county with, because we pay for the insurance, we pay for maintenance, we pay for gasoline, we pay for vehicles, we pay to buy equipment, and then we pay for some salaries.
So are you telling the court that you spend about $1 million a year in drug forfeiture monies?
Yes, sir.
Okay. And what is the balance of drug forfeiture monies right now?
Probably about $5 million.
Okay, so you've got operational needs for at minimum, or not say at the maximum of 5 years,
I hope so.
correct? And that's assuming that no other drug forfeiture monies come in during the next 5 years.
Right.
Okay, all right. Can you just do that? If we can do it, then come up with an amount that you believe you can help out with.
I'll look into it, okay? I can't promise the court anything, but I'll look
No,
into
it's
it.
okay. I understand. Okay?
Yes, sir.
All right. Thank you, sir.
I just want to make sure that we get you operationally efficient first, because that's where we need to start.
Right, and like we mentioned, that, our sheriff's office and our jail is the first line, and then it kind of, what's inputted by the deputies and then inputted in the jail, so is what everybody else is going to use in the courts and the district clerk and the county clerk's office. So it's important that they have their infrastructure in place.
Let me add some more money to the pot by asking what it would cost to have the deputy sheriffs have electronic ticketing available to them that would certainly work well with our Odyssey system for processing the tickets and the magistrate, and the just a processing period if they had the new type of ticket processing that the DPS has. Do we have any idea what that would cost?
I do not know.
Because that's an actual issue that's really important. If we want to see the amount of JP monies owed ever come down, we need to have the sheriff have the equipment he needs for the, that's just part of what we need to make this happen. And it's a big part.
I agree.
Electronic processing the tickets.
So Arnold, let me ask you something. The 37,000 that we're talking about, that's in the sheriff's department,
That's
but then,
in the jail?
well, you have sheriff, you have 20, which is a laptop pedestals, and then you have 29 something, doesn't that?
Those are computers.
Okay, so that's about 37, right? But then if you go back up, you have the cameras, the live scan, the signature pads.
Computers.
Okay,
It's in the jail.
that's in the jail. So actually, we're just talking about the 37,000 down here.
The 37,000 that Shalana was talking about was the one going actually to the jail for the by the cameras, the live scans, and the signature pads. And there's a few other, probably a couple of computers that we can use. There's about $37,000 or $38,000 that we can use from there to use to purchase towards that.
It doesn't include the computers.
Okay. Thank you.
Anything else? Well, let me ask a question then on that part. On the amount that we show for the jail, it's about 22, 27, about 70 some odd $1,000, correct? You add them up?
Yes.
20, 25, 26, 26.
And then you still need the licenses. Okay, for all those
The
computers.
total licenses on the bottom is $100,000.
Okay.
For everybody.
Martha, are other departments that are within here, do they have any lap salaries with them? I'm thinking about using I don't know if it would be right to take the whole $100 and some odd $1,000 from the jail lap salaries versus just taking what pertains to them, which would be the $75,000 or $80,000.
No, there's more.
There's more what?
There's more cost than that.
Well, whatever the number is, it's not.
It's like 150,000.
Oh boy, you're including the two sheriffs at the bottom?
Yes.
Yeah, but see, they've already committed to spending $37,000 from commissary. That'll cover the $5,000 and the $31,400.
Oh, I see.
Correct? So then if we go back up to the jail, and that's around $71,000, taking lap salaries from there that the jail has, and let's pay for that out of the jail lap salaries. And that still leaves us a good chunk if we need it for contingencies. So if we do that, now we're down to about 800 and something thousand, or 780,000 to try to fund. Okay, the DA has, oh, Renee left. The DA has some items here. Has anyone reached out to the DA about having him pay from his drug forfeiture funds?
I spoke to the DA, and he was not in agreement to use his
How
forfeiture
about lab
funds.
salaries? Do they have lab salaries?
They probably do.
Why don't we just look at lab salaries that we have control over?
For each department?
For each department that's needing equipment. Look at all the lab salaries and fund it.
Yeah.
I mean, let's quit.
We don't just hit the sheriff, but hit everybody.
Right. Right. Well, let me talk to the DA and see if we can get him to, let me ask you, because when the budget comes up, have you spoken to the DA about that $200,000 transfer that we've been receiving over the last couple of years?
Yeah, we're going to talk about that when we get to the.
Right.
To
I spoke to
And I
him.
gather if you're up, it's bad news, right?
I spoke to him briefly about that, just in passing, and he said he would think about it and take it under.
Okay, let me,
Advisement of the court.
There you go.
let me visit with
He
him
would
on
reach
that,
out.
too. Okay, anything else that, what I'm, the court's trying to whittle down the amount.
Yeah, they're
There's
small.
5,000.
So we need to, I think when you look at all this, we're talking like everything, like painting everything with a broad stroke, and I think we need to differentiate that. I know Jack Brown is here, maybe he has a comment to make for us.
Jack?
He's an engineer, he does a lot of this stuff.
Longtime county engineer as well.
He's county.
Long time ago.
engineer, I mean.
In a galaxy far, far away.
We've got many, many different issues here. Commissioner Garza's concern about the frontage of the lot and the size of the lot is a very good point. At one point in time, we had the requirement that lots of less than 100-foot frontage would have to have curb and gutter. I think that's a proper thing, and I would recommend that to the court. You might want to cut it down to 90, but at some point in time, you realize that you get to a lot that's so small that you try to put in a culvert, you might as well put in curb and gutter. Many years ago, I think it was even before Judge Coscos was on the court, we took bids on a project in Harlingen in one of the colonials west of there. They had 50 and 60-foot lots. We bid it with curb and gutter, and we bid it with rural section replacing the culverts. It was just cheap to do curb and gutter. That was a grant program and today it still has curb and gutter.
So you're saying that the idea of curb and gutter for county requirements in congested or small lot areas, small lot size areas is not a bad thing to consider?
No, that's the whole purpose of curb and gutter. That's why it was invented, is for urban lots that have, small frontage, so that we can keep the flow lines there, so we can keep the drainage there. And
well, that's an engineering issue.
right, well, those are engineering issues, but there is another issue with curb and gutter that the county has to realize is maintenance of it. Once the developer's done with it for a year, it's your job to maintain it. And I have seen rural subdivision, I remember one just adjacent to the city of Brownsville. It was curb and gutted to city of Brownsville specifications. You go out there and look at it, there was 24 feet of open space and the curb and gutter was grown up in trees, 3 inches in diameter. Because curb and gutter has to be maintained by keeping it clean. That's why we have street sweepers. So if you want curb and gutter, that's great. There is a purpose for it. There's a reason for it. Restrict it to 100-foot frontage, and you've taken care of that. If the developer wants to build small lots, less than 100 feet, he's going to do curb and gutter. But the county has to be responsible to maintain it after the year's maintenance by the contractor and the developer's up. So that's one issue.
Jack, in regard to that, would the requirements for runoff and water and detention ponds, whatever they're called, I mean, are they very different from a rural cross-section collection system versus a curb and gutter system?
No, sir. Well, they're different because the density of the lots are different. And that's just an engineering issue that, we in the engineering department deal with all the time.
So that's not something that is...
That's not a big issue.
It's not a make or break thing.
No, it's not a make or break thing. But when a developer goes in, if he knows that for less than 100-foot frontage, he has to do curb and gutter, then he's gonna examine it. Do I have a proper outfall? Do I have enough slope to the land? Can I do this? Is it feasible? He comes to us and says, you know, what's it gonna cost me? We tell him, and then he either buys the property or doesn't. You know, if he can make a profit, he will. The issue of sidewalks, which, you know, I got off of that, but that comes back into play. I've been actively involved in engineering for over 40 years. I have observed sidewalks in rural cross-section applications in the past. They don't work. How do you maintain a rural cross-section? You take your motor grader out there, you blade out the ditch when it gets silted in. What happens then? The sidewalk gets torn up. With curb and gutter, sidewalks are fine. They work well. They stay there. I used to live in a subdivision, the house was 60 years old. Sidewalk was fine because it had curb and gutter. Sidewalks and curb and gutter go well together. Sidewalks and bar ditches don't work. I can assure you that. The 5-foot easement on private property brings up another issue of liability. The sidewalk gets tore up, who's liable for it? Is the county going to maintain it? You expect the homeowners to maintain it. And then a kid runs a skateboard down there and crashes and burns and hurts himself. Who's liable? So for the developers, it's a big, big issue with rural cross-section. With urban cross-sections, they don't have a problem with it.
Yeah, but how many subdivisions are being worked on today that do not pave their streets?
Do not pave the streets?
Yeah.
None.
Okay. And the cross-section rural asphalt, you're talking about a paved street, bar ditch, and a potential sidewalk, correct?
Correct.
There's a sidewalk about a mile long in Villanueva that was built back, I think you may have been the county engineer, that we built. It's almost a mile, goes right through the whole neighborhood of Villanueva. It stops at a point, and that sidewalk is adjacent to a bar ditch. And that sidewalk is at least 15 years old. And it's still there, it still works fine, hasn't deteriorated. I don't believe we've even had crews out there to maintain them. And I was there a week ago and just happened to look at it, and it was still in shape. So I don't know where it's coming from that if you build a sidewalk next to a bar ditch, it doesn't work.
Depends how far, I guess. It depends how far it is from the bar ditch.
It's about 3
and
feet.
How often it gets graded, or?
It depends on a number of factors. I will go and look at Villanueva.
Yeah, it's right
for my own
on,
education.
right across the street from the school. Villanueva is just outside of Brownsville, about 8 miles.
But I'll go look at it for my own education.
But this is in front of the Villanueva school, so it's in the San Pedro, but the Villanueva school.
It's in San Pedro.
Yeah. You know where it is.
Yeah.
But, you know, if a neighborhood wants sidewalks, under existing laws, and I defer to the legal eagles on this, but I don't know that you have the ability to require, or the authority to require a sidewalk on a private easement on private property. No, I don't know.
I think that was Commissioner Gatsa's point. I don't think that we do. That's why it's imperative that we, basically, part of our requirements is that we ask the developer to put in sidewalks. Now, maybe we need to come up with certain size subdivisions. If it's a 3-lot subdivision or 4-lot subdivision, I understand, but if it gets past a certain number, whether it's 15 or on above or 18, we can add stipulations as far as that. But look, to do nothing is not the answer. To sit here and just say, well, we can't do it, that's not my intent. My intent is to require them to put something.
I think there is a solution to it for the neighborhoods that want sidewalks. If they come to Commissioner's Court and say, we want sidewalks, they sign a petition, you go put the sidewalks in, you design them, you build them, you're responsible for them, and you bill them for it. You have the authority to do that. That's very simple and straightforward. And it's built when there's enough people there that the sidewalk is useful. A sidewalk that goes, 1 lot, 2 lots, 3 lots, and then stops is worthless. But if a neighborhood wants sidewalks, and they come to this court and ask for it, build it and assess them. You have that authority.
But why would we want to pay for that and not have the developer pay for it? I mean, they pay for the construction of the streets.
Right.
I mean, why would we go in and...
At some point, it becomes excessively expensive to develop the lots. We hadn't done subdivision for several years because it was too expensive. There wasn't any market for it. You lose the viability at some point. The water, fine. The sewer, fine. The streets, developers are all good with that. Streetlights, they don't have an issue with streetlights as long as it's, you know, reasonable. Each intersection, end of a cul-de-sac, maybe every 600 feet within the street, they don't have a problem with that. They see that as value added. Sidewalks, when you talk about when the lot is sold, is the lot sold when somebody signs a contract to buy
Way
it?
back in that subdivision to get picked up to school or get dropped off from school. Those are the issues that are.
If you're going to require sidewalks where you have sanitary sewer service already in the new subdivisions, I think that's a great idea. But on the ones where you have borrowed ditches and stuff, it's a little bit different to install them and maintain them before the part of the issue was last time that they wanted to put them in while the lots were being cut up and before they were even sold. And the problem I saw was having to go back in and cut them again to put a driveway.
Well, this subdivision I'm talking about are not urban section roads. They're rural cross section with curb and gutter.
Sure.
They're giving us a space for the drainage ditch or the ditch, bar ditch, whatever it's called, you know, but there's no space for sidewalks. But yet, they're 38-foot frontage on the road, or a maximum of 50-foot frontage of the road. And it's really narrow lot. I mean, we're making city lots out in the country, but we have a different standard.
I guess my biggest concern is installing sidewalks before anything's even put there. It just is,
I think there's-
cement trucks damage them, there's
Yeah,
so many ways to damage a lot.
I think there's a way to, to do this. If you all remember years ago when we were requiring the letter of credit for septic tanks, and because there was no provision that required a developer to install the septic tanks. So we started requiring either a bond or a letter of credit that would force them to install septic tanks when they sold the lot. Is that correct?
Yes.
Okay. So I understand what you're saying. So I don't know why we cannot, look, no developer is going to come and say, oh yeah, I want to put sidewalks in because of the additional cost. Well, I don't think that that's our deal. I think that our deal is to provide a safe neighborhood where we can. I believe that we need to require, under certain circumstances, and that's where you guys come in, sidewalks in these new subdivisions. If the developer comes and says, well, we're going to have to pass that along to the ultimate consumer, well, that's the developer's deal. I mean, that's going to depend on how much profit he wants to make on that lot. It's a free market. The consumer can buy where they want. But I think to not do anything that was not the intent. The intent was to go back and try to reasonably come up with some suggestions. What I'm hearing is that the developer really is not doing anything. They're just saying, we're not going to build anything. So why is it that we cannot ask, to avoid the building, ask them to come up with something similar that we do with septic tanks? You put up a deposit for the construction of a sidewalk when the lot is sold, then you can build a sidewalk versus building a sidewalk on a bunch of empty lots. I understand that. And that way you're ensured that when that lot is sold, a sidewalk would be built at the developer's expense. But it's not done until the lot is sold. So it's the same thing as putting up a letter of credit for a septic tank. Put up a letter of credit for the construction of a sidewalk.
Yeah, that option was looked into, and of course, it was, like I said, opposition.
Of course, they're not going to like it, but early on, the developers didn't like the septic tank requirement either. And as a matter of fact, in today's agenda, I believe we were extending, some timelines for the septic tank issue. Is that correct? We can do the same thing with the sidewalks. That don't force them to build it until they sell the lot, and they can figure out if they want to add it on or.
They're going to.
The problem, though, Judge, I think the difference between the septic and sidewalks you run into, I think, are that with the septic, it's necessary for immediate occupation of the property. With the sidewalk, because let's say you don't have all the lots sold, what good is partial sidewalk being built going to do when I've got, these 3 lots have a sidewalk, but the next 4 don't because they haven't been sold. So you have a gap. And so the idea there is it doesn't do you any good to have it. To put a sidewalk in would make sense when 95 or 96% of the lots are sold, and then you put it in. But ultimately, it all's going to fall on the consumer, whoever's buying.
And if somebody wants to buy where there's in an old subdivision where there's no sidewalks, they have that right to do so. But if they want to pay a little bit more to get into a neighborhood that has a sidewalk, at least they have that opportunity. You know, it's a buyer's market. I mean, whatever the free market wants to do. But I think that doing nothing is not the answer. I mean, right now, I see doing nothing. We're not doing anything to accommodate, you know, Commissioner Gatz's concerns and yours and your subject. We're not doing anything other than, well, we'll let the family that buys it, if they want it, they can put it in. And we've taken away 5 feet of their property to do it.
Well, actually, what we're suggesting is subdivision per subdivision. The subdivision decide if they want to do that sidewalk.
Yeah, but who's going to decide that?
The co-improvement district or...
What co-improvement, what if there's no homeowner association that is set up? There's no law that requires it.
It would have to be set up.
By whom? By the developer?
The developer could put it in the deed.
Yeah, but if there's no sold lots, who's going to be the homeowners association? If you have one lot that's sold, you're going to have a one-person
Well, no, and that would be the point. It doesn't create until so many are sold.
Well, that's why I think a deposit like we do on the septic, and I think that you're right. I think that the septic tank is a health and safety issue. So are sidewalks, okay? And what I'm suggesting is that we continue looking and have them put up a deposit. You can come up with a number, you know, the septic tanks, we came up with a number of what you believe it would cost to put up a deposit. We can do the same thing with sidewalks. I'm afraid that if we go the route that they want, nothing's going to get done. And we're back in the same situation when no sidewalks are going to be built.
One of the issues you got to be careful with also, Judge, is saying, but when maybe 90% of the lots are sold is one thing. It's when the lots are actually built on is the real issue, because they can stay empty for a long, long time, even though they're all sold. But they'll sell 100% of the lots and they're gone. And that's when, like with the light issue, we talked about where all of a sudden the developer turns the lights off. Once he's sold out, he's out. Right. And so I think there has to be an issue of when the homes are actually built.
But if the buyer knows coming in, hey, I'm buying this property here, but when 90% of these lots are sold, I'm going to have to put in my segment of the sidewalk. They choose whether to buy or not there. They don't have to purchase a lot, but you have the problem that if someone goes in and buys 10 lots and decides, oh, I'm not going to build, and everyone else already bought and they're ready for their sidewalk, but they can't get it put in because this guy just doesn't want to build yet. I mean, it kind of stalls everyone.
Sure does.
So I think if it's put in as a deed restriction, and we don't have to do it on every single plat we approve, we could say where the plots are, significantly small in size, that it's a safety hazard, we could say we'll require it. I mean, I don't see with acre lots that we would need to require sidewalks versus, the 38-foot that he's talking about.
But if we're talking about 8,000 to 10,000 square foot lots, we're talking about small lots, not like your typical country, county type lots. And I think we need to differentiate that, especially with the developers, is we're not talking about every development that occurs in Cameron County. I think we need to, I think your point is well taken, judges, what you say, but I think we need to look at the size and the congestion and concentration of the subdivisions that we're looking at. Because those are the ones, when you have a subdivision that is developing, 300 to 900 lots, you're going to have congestion. You're going to have safety issues. You're going to have lighting issues. You're going to have all of the issues associated with those types of developments. And, they're a little city. There's one across where I live, like Ventry area, that was developed. And it's like a little city already. It's now they're looking for lighting. Fortunately, it's not in my precinct.
Where is that?
Ventry. Where's that? Off of 732. Okay, but they're highly concentrated areas, because why? Because they have sewer service provided.
And most of these lots are like 5,000 square feet, David.
He's all bruised, can't you tell?
Last time we met, you asked us, the court asked us or directed us to meet with county developers and engineers. We did set up a workshop, and we had a pretty good discussion. There was two areas of discussion. One was installation of concrete sidewalks in county subdivisions, and also the installation of street lights. I think the meeting went well. We were represented pretty well with the developers. I think three developers showed up and a couple of the engineers. And your packet of information, there's some minutes there, pretty much a summary of that discussion, and also some of the recommendations that they had consensus on. I've got Alex here this morning to just go over briefly the summary of the discussions that we had and some of the recommendations, and then we'll open up for some questions and guidance from the court to see how we're going to proceed forward. Alex, you want to start with the concrete stuff?
Morning.
Alex.
On the sidewalks, there were basically a couple of discussions, but the recommendations that one of the engineers was that maybe we had to do like a homeowners association or some kind of like a petition for each subdivision to have a sidewalk. The big thing was the expense for the subdividers up front, and that some of the subdivisions couldn't even have sidewalks were not feasible. So, so basically the engineer decided to give a recommendation for the property owners to be responsible for the cost and maintenance. They recommended a 5-foot easement and to be on private property. And that was for the sidewalks.
Would that not be considered like a taking?
We haven't.
I mean, if we would require, if we as a court would require an easement as a court for a sidewalk, we're in essence doing a taking of private property. And I would not favor doing a taking of private property. Because, you know, there's property rights in the state of Texas, the last I heard, except for the beach.
I'm not very quite sure on that.
Well, why don't we just kind of...
Well, no. He said, what I heard you say was that they were recommending a 5-foot easement on private property.
Correct.
If we require a 5-foot easement on private property, we're actually doing a taking, okay? And I don't think that we are in a position to do a taking. I don't think that was the intent of any discussion I had, and maybe Bruce can enlighten me on that if I'm totally way off guard there.
Unless I misunderstand, I think what we're talking about is these subdividers, these developers, having a piece of land to sell. And it sounds as if they're agreeing voluntarily on their land to attach an easement before it's sold to the buyer. Is that what you're talking about?
Yes, that's correct. That could be the taking of what the commissioner was saying, but it'll be through the platting process. In other words, before the court approves the plat, that will be already discussed and agreed to with the developer of the land. And that can be, you know, that 5-foot for that purpose only for concrete installation within the 5 feet of the right-of-way line or into private property. You know, and that can be done through the planning process, and then if there's existing property, you may have to acquire that additional 5-foot right-of-way if it's not in a development stage, in other words, in an existing subdivision.
I think, Commissioner, you're right. I think if we make it, countywide on all existing subdivisions, for example, you definitely have a real takings issue there. You would otherwise, without a voluntary imposition of that easement over that 5 foot on either side of the drive easement, or right-of-way, I should say, without that, you'd have a takings problem there too. So it's something to be looked at, I think, legally, to see where we would stand on it and whether we're in the business of, compensating present landowners for an additional 5 feet.
And the main problem would be for rural sections, that you have the ditch kind of close to the sidewalk. So that was one of the issues. And that's why they decided to have it outside of the right of way, in the 5 feet.
So you would have, picture this, you would have the road, then you would have a bar ditch, then you would have a sidewalk,
Right.
correct?
Correct.
But bottom line is, what I'm hearing is that the developer does not want to, and look, the reason that we asked you to go back and visit with them was not to axe everything and not say, oh, we're not going to do anything. It was try to come up with a compromise as to how they need to provide the sidewalks to these new subdivisions. And that's not what y'all came away with at the meeting, did you?
Well, we did in a sense, but the thing is that they were saying that there wasn't that many criteria or accidents that would prove that a sidewalk is needed. That was one of the issues. The other one was that most people were not using the sidewalks. And
Well, they don't use the sidewalk because they're not built. Look,
but in the areas that there is sidewalks.
Where do we have sidewalks in the county? Are they used in Cameron Park? I mean, are kids using them to go to school?
Well, we have to, the unique part about Camp Park is we do have curb and gutter. And so, we have a transition from a paved road to a curb and then a sidewalk, which is.
Not the bar ditch.
The difference we have in Cameron Park, Commissioners, is we have a sewer system. So we don't have borrowed ditches. So we actually have sidewalks. So and it was part of a big program to do the whole neighborhood. It's not a normal circumstance.
What brought this to light was we have 3 subdivisions that we have preliminarily approved, okay, that all have sewer systems.
And no sidewalk.
Not systems, but sewer services provided. to them.
Sanitary sewer service.
Yeah, they've got some, and what has occurred, in the past, we had large lots that we were working with. Minimal 100-foot frontage, they had to have half an acre space to do their sewer system installation with. But now, the lot sizes that we're looking at, and I know you just got one approved in your precinct, I just got 1 or 2 approved in mine, or we're basically doing city lots in the county now because of the sewer service provided, okay? But we're not requiring what occurs in the cities. And we have very concentrated areas. I had concerns, and I brought concerns to this commission about a lot that was 38 feet wide, and I brought it to you all, a frontage on the cul-de-sac in that particular subdivision, okay? I mean, 38 feet, you can park a car there, and if you park a car there, you barely have space for a driveway going into the house, And then you're packing these things like sardines. Where do people walk to their mail, because they're gonna have cluster mailboxes on 1847, or 732 in your case. Where are they gonna get picked up? The bus is not gonna drive in to pick up kids, they're gonna pick them up on the road. How are the kids gonna walk from?
Would be the mandatory increase that we would have to give the county courts at
To
law.
the courts at law, yes.
Right, beginning September 1st,
Yes.
correct?
Yeah. Correct.
And that would be how much? On an annual basis?
On an annual basis, it'd be 15.
15,000 each?
Each, yes.
Okay, $45,000.
Right.
Okay. We also give the district judges a supplement of how much? Each?
15,000.
Right now, 15.
Okay.
You're
So why
maximizing.
wouldn't we not, in order so it would be budget neutral, you take away the district judges, and I don't think that they were lobbying for it, but they received an increase, so why wouldn't we not want to decrease the supplement that we're giving the district judges from general fund, and using that money to give the supplement, or whatever the mandatory is for the county courts at law?
Well, you have
And leave the
the,
difference, I mean, whatever it is.
you have the district judges and the court at law judges that serve on the juvenile board, and they
Well,
are entitled to
Yeah,
additional
but apart
compensation
from
for
that, I mean, whatever the number is that we need to take it to, so they, in essence, we reduce the amount of supplement, less the juvenile board money, and use that money to give, to help offset the cost to the county courts at law.
Well, you wouldn't have to, if you take away the supplement to the district judges, you don't have to increase the county court or law judges. They just have to make $1,000 less than the total that the district judges make.
The total, not.
Well, I just think it ought to be budget neutral, because all of a sudden, you know, it's a mandate that we don't have to do. If we budget this right, this will not have a general fund effect on us. If we leave it the way it is and do it, it's going to have $45,000 effect on us per year.
And then we give raises, whatever we give all employees, we give across the board.
Yeah, but you can't give them once the county courts of law reach that threshold, really, they can't, I guess they could, but they don't go.
Because you're giving both of them.
Well, you have to increase the supplement to the district judges too.
Right, you give them across the board.
Yeah, but right now,
There's
we're,
a max, they have a cap also.
yeah, all I'm saying is that to avoid having us go out of pocket $45,000, you reduce whatever the supplements that we're giving from general fund to the district judges, because they got a raise. They got a raise of $15,000 from the state, correct?
Yes.
Okay, so then, and in order to satisfy what we need to do with the county courts at law, you take whatever supplements we can that we're funding from the general fund to the district judges, take that away and give it to the county courts of law, so we're in compliance.
That's what I'm saying. If you take it away from the district judges,
You
you
don't
don't
have to
have
give
to
it.
raise the county court or law judges.
Right, because your
Because
court at law
they're
judges
already $1,000
stay at 139.
Oh, I see what you're saying.
Right.
So we're giving the supplement is right now $15,000? Is that our supplement?
Well, the Commissioners Court has always, from my understanding, has always supplemented the district judges the maximum allotment that's allowed by the Appropriations Act. And the maximum allotment, the maximum supplement actually went up from 15,000 to 18,000 this year,
That's another,
3,000.
Another 20,000.
Because, yeah, if you take the supplement away.
I mean, we're just discussing this, we're not making a
Right.
decision, right?
Right.
Then in
yeah.
essence, they didn't get a raise. They're staying the same.
Who?
Everyone
The
else
district
did
judges.
except for Cameron County judges.
Right, the district judges. If you
Right.
take the supplement away,
They
I mean,
didn't get a
they stay
raise.
at their total salary, it's what they were earning before.
Rather, it shifts the funding mechanism out to the state as opposed to the county and the state.
They are state employees, right?
Yes.
We'll send Dan the news.
And
Well, I mean, I just don't know why, I mean, look, I mean, if you look at it, I mean, we have the authority to reduce the general fund, and really not giving a raise when other county employees are not gonna get a raise. And the state has authorized them getting a 20% raise or 15% raise, and we're talking about giving employees $500 or $1,000, and these, I mean, well-deserved, I'm sure, but if we have a chance to save some money and transfer it over to the other end, I think we need to do that.
And then if we give a raise of $1,000 across the board.
We gave it to
they're
everybody.
included across the board.
As a
Whether
supplement.
You're a district judge or a county
Right.
court of law judge, it won't matter because it'd be the same increase.
That way it's fair.
right.
All right, okay, go ahead.
For Friday or the meeting of the 18th, we will have a budget amendment coming to court because we will need to cover the $4,200 that the court at law judges have to get paid for the month of September.
Well, and then would we have to make a decision at that point as to where that supplement would come from, as how we fund the county courts of law as well?
For
No, it's just for that
FY13,
month
it's ju-
because
it's
the
for that
salary's
1
already
month.
set.
It's for that 1 month.
You're gonna include it in this coming Friday's meeting?
Well, no, for the
I don't-
18th.
For the
Oh,
18th.
okay, 'cause
But
we
we'll
don't-
we'll have a budget amendment because that pay increase will take effect September 1st by statute.
Right.
Yeah, but you got the whole month of August.
Correct. Well, it's an FYI to the court.
Let's-
Martha
give us a
doesn't
little
like to
discussion
procrastinate.
time.
Martha, I have,
That's
the
not-
district
that's not as
judges,
important
remember
as
that.
everything else.
I had one question. I've kind of followed the workman's comp monies for the last couple of years as to what we actually spend, what we pay in premiums, as to what we actually spend, and there's been a big gap. in that number. It will, if we change, will that work, when we change our, if we change our workman's comp procedures, that should be a big savings to us, or do you keep that money in some kind of separate issue, a separate pot that we can't touch? I know our claims have been maybe running $500,000, and our premium's been running about $1 million, maybe 600,000, so there's always a big gap every year. I think Commissioner Sunshine talked about this a couple of times. What happens to that extra 400,000 this year if we change the way we do workman's comp? Would that come back to general fund, or does that stay in a separate?
To the individual funds where they're charged, is where it
Right.
would stay. Yeah, because that premium is broken up, general fund, road and bridge system, all the grants.
Okay.
Yeah.
So it wouldn't have a big effect on general fund, or it would?
It all depends on exactly what gets approved, when it gets approved, and
So do we approve workman's comp, a new policy for workman's comp, before we do the budget or after? Before we complete the budget or after the budget cycle?
I don't know when you have it,
I don't
you're going
know
out
either.
for proposals, aren't you?
Yeah.
I mean,
Are we out for proposals right now?
I don't know what the timeline is. Recommendation?
Okay.
Final RFP to go out.
Oh, so, but when's it due back? I would imagine 60 days. So you're end of September? I don't
It
know
would
that-
be too late.
Too
Right.
late? Okay.
Right.
All right. Do I hear a motion, anything else?
No, so as far as individual workshops or with the departments, you want to do that, you don't want to do that, so I guess that way we,
You know, if any member of the court wishes to meet with everybody or you all, that's fine, but I think that we may be wasting their time and ours if we don't, I mean, we're already short, correct?
correct.
So, you know, I mean, if you want to meet with everybody, that's fine, but I just don't want to waste their time if we're not going to be able to provide what they need without doing some cuts somewhere else.
We'll have the exact amount as soon as we get the values from the appraisal.
Which will be later on this month. I mean, the preliminary values, we received two sets.
I know my tax.
And we actually, there was an increase between the first and the second, which it's not really normal. The last, there was an increase in valuations of just over 4%. In the past, historically, it would drop from the preliminary values to the final certified values. There's still a lot of properties that are still under protest. And so around the 25th, 28th, we will receive the certified values. And plus, I'm not sure at what point we're going to know, because last year it was a little late, as to the actual properties and the increases in values that are within the various TERSs that the county is participating in. So that cuts into the increase that comes to the county. So, but as we move forward, we'll keep you updated.
All right.
Thanks for all the great information.
Do I hear a motion to acknowledge?
So moved.
By Commissioner Hernandez, do I have a second?
Second.
By Commissioner Sanchez, all in favor, signify by saying aye.
Aye.
Any opposed, item carries. Item E, consideration and possible action regarding installation of concrete sidewalks and streetlights on subdivision developments within the County of Cameron jurisdiction. Ernesto. How did your workshop go with the developers?
Good.
Good.
As a matter of fact,
Okay, we'll bring it back to the next meeting and, I mean, because it's like Commissioner Garza says, we need somebody there. If the manager, maybe because he has a larger family or whatever, needs more space, you know, and went and bought a house somewhere else, I can understand why you'd want to do that. But as long as we're getting what we need done and it's not costing us more money, I don't see why we would want to oppose it.
I mean, it's the same thing as the current at Andy Bowie, right? That's correct. Same thing, you know.
And if you start a fishing guide service, we need to know.
Let us know.
You mean letting us know again? All right.
I would recommend that the court, if they're going to approve that, to approve it subject to negotiating a lease agreement with this individual so that the county will have the reinforcement to collect the rent.
Where was the employee living before?
Brownsville.
So now he's moving, basically, or?
Oh, you're talking about the one that wants to move in
The
there?
new one, yeah.
He lives in Harlingen.
Okay, and he's going to leave wherever he's at and go live over here?
And live
It's a
over
lot
here.
easier to not have to commute that far.
Yeah, no, I agree. All right, okay. So what do y'all want to do?
Can we approve it subject to legal working out an agreement?
Move to approve, subject to legal working out a lease agreement and and changing the job description on the new individual to accept the duties.
And the manager.
And changing the job description of the manager not to require him to live there anymore, as long as one of the employees does live there.
Second.
Moved by Commissioner Sanchez, second by Commissioner Gatsa. All in favor, signify by saying aye.
Aye.
Any opposed? Carries. Item L, discussion and possible action to allow the Cameron County Parks and Recreation Department to solicit invitation to bids for possible land lease.
Judge, Commissioners,
Is there an executive session item on that? No? Okay.
we had an interested party that was wanting to put a wind measuring devices at the flats at Andy Bowie. So we prepared a draft invitation to bid. They're interested in using it for 2 years. We brought this to the court, see if the court was interested in allowing us to go out for bids.
How tall is that thing?
I don't know the height of it.
497 feet. That's the height of the wind farms.
Is that how high one of these things is?
How much are they?
I'm not sure.
497.
The
So
height-
we're thinking about allowing someone to put up I guess, a big wind measurement device out in the flats, in the middle of nowhere, just out there sticking up like a sore thumb.
Gives the place some character.
I mean, I'm not sure if y'all are interested in doing that.
Why don't they go to private property?
Well, I think, I mean, they could, they just need to locate, need to find a place that's.
I think
close.
aesthetically, I mean, it just doesn't look, I mean, it's right across from the shores and all those other, right across, I mean.
Well, that'd be a good parking lot for Clayton to park all kinds of people over there, right? The flats.
That's where they need
And
to
they
go.
could.
Because you can park there and still see the fireworks, right?
That's where they need to go.
I just don't know if that's where we want to go. I mean,
Okay.
putting something up like that in the middle of the flats, the middle of the island like that, just aesthetically, just doesn't appeal to me unless it does to you guys. Doesn't appeal to me at all.
Unless it's going to be like an observation deck for SpaceX, then
Well,
probably not.
if
No,
there were no private property there, I could see it, but I mean, there's a lot of private property.
And that's where they do the kite flying thing, don't they?
Yeah.
What they're wanting to do is in preparation of the wind farms offshore, they need it for two years to be able to collect some of this data.
And they can't put it at the top of one of the tall buildings on the island?
I'm not sure what research they've done.
Doesn't the Coast Guard have like a tower also over there?
On the south end.
Top of the causeway?
Couldn't they get a private property owner that's further north on the island, maybe right on the Willacy County line, that they can somehow lease
Doyle
from
Wells.
them or something? I just don't think it'd be a good idea to have it that close in.
Table it?
No, I don't want to table, I want to just deny it. I guess we could table it forever, but, send them that we can't. I mean, I don't think we should.
Move to table.
Moved by
Second.
Commissioner Gatsa, second by Commissioner Sanchez to table. All in favor, signify by saying aye.
Aye.
Any opposed, item carries. And Javier, if they need your help, maybe to contact some of the property owners that are way north and work something out with them. I mean, there's nothing out there.
Right.
All right?
Okay.
Thank you. Item M, discussion and possible action on the concession terms for a Cameron County Native Plant Center related to temporary housing on the premises.
This is, Dilby is working on a lease agreement with Thor Lassen for the Native Plant Center. And one of the things that Thor was requesting was to allow internships to be able to stay on premises during, their studies. And Dilby wanted me to put this on to see if we wanted to allow that, so she can insert that in her agreement.
When you talk about staying, what does that mean? Like camping out or what?
Well, no, they would have a residence.
They'd be like kind of like the park thing, where they'd be an apartment or a room with a.
But there's nothing there now, is there?
No, but in the architectural.
To build
process,
something.
In the build process, they're looking at incorporating that, just like Sea Turtle Link is doing the same thing. They have these interns coming in from the university.
I don't think that's a big deal.
Like a caretaker home type?
Yeah,
something like that.
I don't think that's, I think that's okay. I mean,
Well, and a lot of,
Within the building itself?
right, and a lot of the, like, some of the interns, we have like the Sea Turtle Link people now
Efficiency apartment type.
are in FEMA trailers at Indy Bowie Park.
all right, y'all have any problem with that? No?
Move to
Motion to
approve.
approve
Second.
by Commissioner Sanchez, second by Commissioner Gatz, all in favor, signify by saying aye.
Aye.
Any opposed, item carries. We have a supplemental, and it's one action item that we will discuss after executive session along with the other ones. Do I hear a motion to go into executive session? So moved. By Commissioner Hernandez, second by Commissioner Benavides. All in favor, signify by saying aye. Any opposed, item carries. To discuss the following items related to pursuant to Code Section 551.072, 551.0712, and 551.087, 551.0712, 551.072 and 551.0712, 551.087 and 551.0712, 551.011A and 2, and 551.072. We'll be back. Was that you that burped? That solves that problem part about building the sidewalk where they're going to put their driveway. You don't build it up. All I'm saying is that developers have to come and, just like they do with the septic tanks, I don't see why they cannot come up with a letter of credit to ensure the building of a sidewalk. And maybe you could tie it into once 80 or 90% of the subdivision is complete. There's got to be something.
The only thing about that is that there is no state statute that you can use to enforce it. We can develop an order and the court can consider.
Well, we don't have to apply, we don't have to approve subdivision plats if they don't have that.
Can we deny
I don't
the
know.
approval? I don't
That's
think
a
we
legal
can.
question that needs to be in, because unfortunately in the state of Texas, counties only have the authority the legislature gives you. Have they given you that authority?
I don't know.
I don't know either.
The health and safety of the public.
No, I'm not talking about the sidewalks. I'm talking about having them put a deposit, like a letter of credit to build the sidewalk as part of, just like we did when we had the flooding issue. And I said, look, I mean, what we were doing at the time was just making sure the water went out of the subdivision. We didn't follow it to see where it ended up, so it was always ending up in somebody else's subdivision. Remember that? Commissioner Tamayo was on
Mariposa Ranch.
on the commission. And so we decided from now on, it's not just getting the water off of that subdivision. Where does it ultimately end up, so it doesn't end up in somebody else's backyard? So I think we can do that. But anyway, let me have a motion to table it and then just put it back on the agenda when you're ready.
So moved.
Second by
Second.
Commissioner Gatsa, second by Commissioner Sanchez. All in favor, signify by saying aye.
Aye.
Any opposed, item carries. Jax, good to see you. Take care of yourself. Item
Thank you
G,
for the
consideration approval of reclass and salary adjustment of human resources. Arnold, that's
Yeah, that
you.
would be reclassifying and adjusting the salary for the Human Resources Law Enforcement Coordinator to Administrative Assistant to Administrative Services Director.
Who's going to be taking over the law enforcement side of what they were doing?
Right now, I worked that out with what they were doing the background checks. That's what Mr. Frizzell would do. I worked that out with emergency management, and they've been doing those background checks for us. And I checked with Susie, and that's been working just fine.
Working okay? All right. Do I hear a motion to approve?
At a savings of how much?
A little over $7,000.
So
Second.
moved.
Moved by Commissioner Benavides, second by Commissioner Gatsa. All in favor, signify by saying aye.
Aye.
Any opposed, item carries. On item H and I, we discuss after executive session. Item J has been discussed. Item K, discussion and possible action on whether to allow an employee to stay in the manager's residence at Adolph Tomei Park. Javier, what's all that about?
Judge, Commissioners, what this is that the manager from Adolph Tomei Park, he bought a home in Brownsville. So he's staying in Brownsville. He's not staying in the residence anymore. So one of the employees that works for us there at Tomei is interested in staying at the residence. The thing is that in his job description for the manager, we did specify that he had to reside on premises. So talking to
Okay,
Bill-
hold on.
Yes.
You have the manager that's there now, that used to live there.
Right.
And that was one of the requirements.
Right.
So he's left to build.
So he resigned by leaving?
He bought a home in Brownsville because it was difficult for his...
He's still the manager, though, right?
Yes, he's still the manager.
Okay, so then, if that was one of the requirements to be the manager, to live on premises, so what does this do now in terms of him living in Brownsville?
His employment.
Yeah, I mean, what happened? I mean, that was one of the requirements that he do that. So is he resigned as the manager?
No, it wasn't, I guess it was a requirement we did after we hired him, because before we had contracts with the managers, as stated, Andy Bowie and Adolphe Tomei, but he bought a home in Brownsville, and now he's not living there. I mean, if that's the situation where he has to resign because of that, then, you know, we'd have to deal with that.
Do we provide him a vehicle, and is he going to be going back
No.
and forth to Brownsville now?
No.
Okay.
Well, I mean, what are you recommending?
I would think, you know, from my perspective, and I've been there a lot lately, I think we need somebody there living there. I think it's helpful to the park. It's helpful for, you know, obvious reasons.
I agree.
That having a presence there is important. I think that.
Are they on call 24/7 or?
They're not, but you knock on the door and
Yeah.
they, you know.
And that was one of the requirements, is that, you know, if it was after hours, if they needed something, then they would go to the.
Respond.
What is the rent on that place?
It's $150.
How much was he paying rent?
$150.
$150 a month.
And what's
Is
the
it one-
average?
Is it 2 units or 1 unit? I mean, it's like separated in 2, right?
Right. The other one is there is a second unit there.
So.
It's a 1-bedroom with a kitchen and a bath.
So there's 2 units.
Right.
So technically, we could offer 2 people to utilize that area,
Right.
okay? And which might not be a bad idea of their employees, because, you know, the presence there makes a big difference for that part of
Oh, no,
someone.
there's no doubt. No doubt.
But there's no requirement that they actually be there certain hours, right? After hours, they have to go run errands or go grocery
No,
shopping
they
or
do
whatever.
that. They do their
It's
work.
okay.
They're 40 hours, and that's.
Okay.
So are they on, I missed, I'm sorry, I was out. Are they on salary during the day?
Yes.
Are they required to be there?
40-hour
during-
week.
Are they required to be there?
40-hour week. They work a 40-hour week.
Right. They're salary employees.
I have something, I don't want to say it publicly, I'll tell you privately.
No, but this is the time we need to.
Well, I think, you know, the concern I've heard is that there's private fishing charters and things that go on during the day, that these people are doing this. The people, I don't even know the name of the person, I don't know who it is, but they're doing this on the 40-hour county time. And so I don't know if that's proper or not.
The guy that works there?
I don't know. All I'm telling you what I've heard. I don't know if it's a fact or not.
Well, I've heard that Javier Mendez has a fishing charter service operating out of there too.
Oh, do
And
you?
I asked him yesterday, and he says he wishes, but he doesn't. I've heard that, you know, other people have fishing charters. I know that on occasion, you know, when allegations have been made about that occurring, you've checked them out.
Yes.
And according to the timesheets and who's supposed to be there when, that's not been the case. There's, you know, I mean, I had one gentleman yesterday in regards to this item that came to my office, and he was totally upset about the whole Tomei Park, you know, about, you know, the issue of we're trying to get a lease for 25 more years. Because according to him, we're the worst stewards of property that there are anywhere. At the same time, Javier shared a video that he had of volunteers cleaning the opposite side of the arroyo, bringing the trash and unloading it by the county park area to put in the bins. And the video they sent him was saying how people were dumping at the county park, not knowing that there were actually a group of volunteers using their own personal boats to do a cleanup on the other side. So the stories are like crazy, you know. People say things when they only see a very little narrow gap of what's occurring.
All I'm telling you is what I was told. I do
Yeah.
not know if it's fact. I don't want to sit here and say, yes, it's true.
But
I
we
don't know.
checked, it was checked out,
Okay.
because some of us got that same complaint.
Okay.
I still say we need to have somebody living on premises. It makes a huge difference for everybody there, you know, having like eyes. People never know when somebody's around and looking and seeing, because we're not there 24/7.
Could I ask just one question? Did the manager pay rent?
Yes.
Okay, and he's now gone, he's not paying rent anymore?
Right.
And you're talking about letting a new employee pay that rent?
Correct.
Okay.
Would we have to pay that new employee if he's not on salary overtime whenever he's called out, or would that be part of his supplemental pay by getting to live there at a reduced rate?
That's it. You know, I mean,
To me, if that's the case, if that employee's gonna take over the responsibilities that the manager had in terms of being available, I don't see what the big deal is. I say we approve it.
Yeah, I would just have to change his job description and require him to have the same responsibilities.
We're gonna get the money out of these folks.
right. Yeah, and we do that now with those areas that we're
Yeah,
doing.
that can work as long as they agree to participate and do participate.
Because one of the biggest problems we had in installing the lights was getting the right-of-way for the light installations after the fact.
Yeah, no, well, after the fact, it'd be difficult, but in future subdivisions, like I said, my developers don't have an objection to putting in the streetlights and paying for them for a year. But after that, somebody else has to pick up the tab.
That's understandable.
Thank you very much.
Jack, you know that we've seen an evolving, and I guess for those of y'all that have been engineers for a long time, you've seen an evolving of infrastructure and in subdivisions. You know, back in the old days, there was no requirements for septic tanks for the, you know, there was no requirements for anything. Somebody could go out and buy a lot, build whatever they want. I mean, things have evolved, and they've evolved for the betterment, to protect the consumer ultimately, okay? Whether it's requiring septic tank bonds or sidewalks or lighting, it's all there to protect the consumer. I still haven't heard, unless they're gonna come back and give us a look, the recommendation should not be we do nothing. That's not the recommendation. Let's just figure out what's gonna happen. Somehow we need to ensure that maybe for a subdivision that has X amount of lots on it, they're required to put in sidewalks when the lot is sold. I know you can't control when somebody builds. I know that. But I just don't think that we're leaving it up to us to enforce when the developer, they sell their lot, they make their money, they walk away, and they're done. And now it's up to everybody else to try to foot the bill to make some of these improvements. I think the developer, it's their call, but I think they can, how much of a profit do they want to make? Do they want to make less profit? Do they want to sell their lots? So, I mean, I'm not happy with the non-recommendations that you guys are giving us, because you really haven't given us any recommendations other than what the developers told you what they wanted. That's what I'm hearing. I mean,
Well, I think that we need, I don't know, but I think we need to go back and look at the concentration and the size of the lots.
I agree with that.
I think that's a good start.
That I think is an excellent start. Also, if you have curb and gutter, sidewalk is much more viable.
Yes.
So from a developer point of view, you know, it's not cost prohibitive to do curb and gutter in a highly concentrated subdivision.
In a small lot subdivision, no, sir. It's actually cheaper in the long run.
So, you know, I think we
You
need to
just
look
have
at
to
that.
Well, that's what I'm saying, that I think we need to come up with some criteria as size of lots, the number of lots in a subdivision, and you guys need to come up with that. Remember, you know, what we're trying to do is develop something that is not necessarily developer-friendly, but it's more consumer-friendly.
Well, but ultimately, the consumer has to afford the lot.
I understand, you know, and the developer is the one that decides how much of a profit margin they want to make on those lots. Whether it's 20%, 30%, 40%, or 5%. It's their call. It's their call. So where do we go from, I mean, where do we go from here? Are you going to come back and
From hearing what's coming to part here.
back on the mic? Back on the mic.
Yes, sir. I think what I'd like to recommend is we table this item for now. We sit down in another workshop with the developers and the engineers. Let's iron out this particular issues that are of concern, and come back with a recommendation that this is what is going to transpire as far as installation of sidewalks.
Okay.
There may be some legal concerns. that
Well,
we
you
need
know
to-
what, get legal involved, but
You know, as far as
coming
where we're
back
gonna
to
put it
us,
at.
as far as coming back to, you know, to me, is not to do nothing. You know, or you put all the burden on the commission or on Cameron County. The developer's got to do something, and I don't see them giving up anything after y'all's meeting. What did they give up? Really?
They gave up street lighting infrastructure.
Well, they were already agreed to the street
and-
lighting.
And the maintenance for a year. Yeah, but we gotta make sure that at least we give them credit for that, because, I mean,
Yeah, and
that's
I
a big
think
one.
it's a very positive move in that sense, in that utility. I think it's very workable, like the engineer was saying, Jack. We can proceed forward with that, developing policy criteria for it. Continue with that, since we do have a consensus that it can be done, other than who's gonna pay for the energy.
Can you tell me what the cost of providing the lights would be?
2,000?
The
According-
lights are about $2,000 each.
Per-
If you,
yeah.
per light, you put them at each intersection, you need one at an intersection, you need one at the end of a cul-de-sac if you have a cul-de-sac, and then a 600-foot spacing in between. And you're talking about, $300-400 a lot probably.
Okay, and to put in a sidewalk?
Sidewalk's about $1,500 a lot.
Maybe 2,000.
Well, it depends on the width of the lot too.
Well, it depends on whether.
And it
the lot-
depends on whether you have curb and gutter.
Well, if you have,
Yeah, so there's a whole lot of variables there.
Take into consideration as well, I mean, look at some of these other rural cross-section areas that do have sidewalks. Look at what's happened there. Because the judge is talking about one that hasn't had issue, but I don't know how that one compares to anything else out there. And then look at do a projection on the cost and maintenance of what it's going to cost us as a county to maintain these curb and gutter streets and these sidewalks over the lifespan. Because that's something that, I mean, cities have street sweepers, but at the county, I don't know that we have a fleet of street sweepers, and, what that would cost as well.
Well, we would have to develop that, because we don't have any criteria to analyze what is gonna be the projected cost.
Well, I would
Well,
assume
check with
that
cities.
I would assume that the maintenance on a curb and gutter street is less than on a cross-section rural asphalt, right?
Over time.
Over time, yeah, because you don't have anything holding that asphalt together.
And
And
you
curb
could
and gutter, you've got some,
Yeah, you could actually do the maintenance with your current street sweepers that you use for paving, but you're gonna throw the debris up on.
into the
lot.
bar, or onto the bar ditch.
Yeah, but the main thing is that you keep it clean so, trees don't.
Water
grow up.
flows.
Sidewalks, not Wilson Road, Business 83. Talked about repaving, built a beautiful sidewalk adjacent to the curb and gutter. It's blowing out already. There's about 5 sections over there between Harlingen and 800 that are blown out, popped up. So,
All right, so then
that is a
you,
cure.
We haven't even started to talk about some of the calls that we get at my office and possibly some of your offices in regards to handicapped individuals in some of these areas, in trying to access a mailbox or a school bus or whatever. That's a whole other thing that.
Mailboxes, the postal office is now going to the cluster boxes.
Right.
Pretty much everywhere.
Right.
So, we need to provide access to that.
Yeah, EDA has to be incorporated into that sidewalk system, somehow or another, because it is required, that you have to have ramps in or fixtures like that.
all right, okay, so then you want to come back
If it's all right with the court.
after the 18th, then,
Yeah, that we come back and address those issues and concerns of the sidewalks.
And I have a question too. Right now, do we require concrete driveways?
No, they're not a requirement.
So are we going to be able to have a sidewalk made out of concrete and then a driveway that's not? Or is that going to have to be a requirement as well?
That's
Well, we
another
would have
one of
to
the
come-
issues, which is, all right, we build a sidewalk and then you come cut 24 feet of it out to the driveway. What happens there? It's collision. That was my fight.
'Cause, I mean,
Most builders do put in the concrete driveways, but it's not a requirement.
In a curb and gutter situation, almost all of them are concrete or at least asphalt. In a rural situation, they're mostly collegiate.
And we do have criteria for that, as far as design.
well, keep that into consideration as well, because
So I think that if it's all right with the court, we can go ahead and meet and extend the same invitation again to the developers and the engineers and iron out those.
I think you need to visit with this deposit issue, because
Or is the lot sold when that deed is transferred 15 years from now? That's a good question. Do we build the sidewalk when the contract
The
is
lot is
executed?
sold when you make
And we
the
have it
first
there for
payment?
15 years before they put anything on it?
Sign the deed.
Well, what's the cost of that money for 15 years? When you're talking, $1,500 a lot or something on that order. So it's a big expense.
No, it is, Jack, and I understand, someone's got to pay. I mean, it's either going to be the county,
Ultimately,
it's a consumer.
It's the consumer.
That's correct.
It's always
And
ultimately going to be.
But a consumer is going to make that decision, whether they want to pay a little bit extra to go into a subdivision that has a sidewalk and lighting versus one that does not.
Well, once again, lighting is not an issue with the developers I've talked to. They're all okay with that as long as the requirements are reasonable. Sidewalks, it's an upfront cost to them that adds no value.
Let me ask you this, is it an issue for both rural cross-section and urban section roads?
Well, that gets back to the ETJ of the cities. We have very little territory in Cameron County anymore that's not in some cities' ETJ. In fact, maybe out by the refuge, we might have some, but that would be it. I still think that's probably in Brownsville's ETJ. So does the city require sidewalks? Are you
Yes.
going to take care of the sidewalks? Does the city require curb and gutter? Are you going to take care of curb and gutter? So it's a very complex
Well, we
issue.
take care of what we're built, and again, I go back to that same subdivision, that Bentry area, that's a curb and gutter subdivision.
Yeah, but Villanueva, as I recall, was an old subdivision that was already established, probably.
No,
Well,
I'm talking about a brand-new one.
Well, what I'm talking about in San Pedro, it's right across the street from the school. And when I was a commissioner, the issue was kids walking on the street, going to and from that small school. So the county built, through a grant, we built a sidewalk, was about a mile. And we did, all I was trying to say was it's still there, it's working fine, it hasn't deteriorated, and it's been at least 15 to 18 years old. Now, let me ask you a question. If someone is going to develop a subdivision inside of a city limit, what are their requirements? Tell me what their requirements are, infrastructure-wise.
Each city is different. City of Harlingen, they require a sidewalk on one side of an arterial or a collector. A residential street, no sidewalks are required. I'm not sure what it is in Brownsville. I haven't done a subdivision here in years. It's required.
In Brownsville, it's required. So, I guess I know, and I think here's where we get into a disagreement. The requirements in a municipality are somewhat more stringent and requiring than those in the rural areas.
In some respects, yes, but as he stated, in Brownsville, they require a sidewalk on both sides. But in the rural area, they do not require curb and gutter or a sidewalk.
Correct.
City of Brownsville.
Correct.
City of Harlingen, same thing. It goes back to lot size. And at some point, the lot becomes so narrow that bar ditches are no longer feasible. So that's why
Well, maybe that's the criteria we need to set up, come up with something like, look, at the end of the day, I think there's consensus here that sidewalks, however we do it, is a necessity in some of these larger subdivisions.
If the residents want it. To require it up front, I think is a waste of capital.
Well, the residents are going to want it. They're just not going to want to pay for it.
To Commissioner's Court.
Yeah, no, they are going to want it. The issue is who's going to pay for it.
Ultimately, the residents are going to pay for it. If you do an assessment program, you attach a lien to their property. You can do it for paving, you can do it for curb and gutter, you can do it for sidewalks.
Why can't the developer do that? Are they not allowed to do that?
Well, once again, you get back to, okay, many of these lots are sold on a contract for deed. They're out there for 15 years. The lot isn't built on for 15 years. Who's going to take care of it?
I thought that contract for deed stuff was over.
No,
It's still,
it's a warranty deed with vendor's lien now. You call it, it's same thing, a different name. But it's still.
Owner financing.
Owner financing, yes.
okay, so then where do you go from here?
I think where we need to go is we need to look at lot sizes.
Okay.
And we need to look at areas that are being provided a sewer service and don't need a septic drain field, because those are the areas where we're having lots being
Smaller
miniaturized,
Well, we have some subdivisions on the books, and I think we're doing some right now, where the lot sizes are still nearly a half acre, They're rural lot sizes, but they have sewer. Because ultimately, it's viable, if the service is there. Military Highway's been very good about working with the developer to get sanitary sewer service. It's actually more beneficial to the developer to do the sanitary sewer than the septic tank, because the septic tank, he has to put a letter of credit up to you that, holds up his finances, and that goes on in for years and years and years. And one of the issues with septic tanks is, well, after 5 years or however many years, if the developer, or if the owner hasn't built on it or put it in, the developer puts it in. It's in the wrong spot. It's not the right size. There's problems with that program that have never been addressed. There's another issue of the 5-foot easement. Okay, that's on private property, but then Military Highway, East Rio Hondo, whoever, they want a 15-foot easement adjacent to that, and then the electrical provider's going to want a 10-foot easement on that. So already you're 30 feet into the lot with these various easements. If you're going to require sidewalks, you need to require additional right-of-way. 5-foot additional right-of-way on each side, make it a 70-foot road instead of a 60-foot. That way it's on public property, the liability issue is answered, the room is there, and you go from there. And I still believe that the best answer to communities or neighborhoods that want sidewalks is to petition this court, and then you assess them for the cost of those improvements.
Mr. Brown, I have a question. This item also pertains to street lighting. And my suggestion was, having areas that have absolutely no lighting at all, it's a danger, especially at night for the sheriff's department and constables. To ease the cost, I suggested having at least the infrastructure put in for the street lighting, the cable, the pipes, and with the stub ups, at least if the subdivision at one time would like to get together and have a homeowner association and have street lights, then they could do it. It might be much easier before sidewalks go in, driveways, and whatever, houses and whatever mailboxes. Is that a real costly item for
It's relatively low cost, and the developers that I represent have no issue with providing streetlights up front. The only caveat to that is, after the 1 year, the county has to pick up the tab for the streetlights. If the county won't agree to that, then the utility providers will not allow us to have streetlights. If you don't agree to pay for it into the future, they won't let us put them in.
Well, it doesn't necessarily have to be the county, it can be the
Property owner.
property owners.
I don't
As we
think they'll
do-
sign up for that. That's happened in the past and it didn't work.
It's
The
working
homeowners-
well for us right now.
Pardon?
It's working well for us right now.
It hasn't in the past, and my experience with the electrical providers has been that if a municipality or the county does not agree to back up the cost of the power to power that, they won't sign
We're
up.
doing it in Cameron Park and we're doing it in Laguna Heights and in
Well, that's
some
good.
other, and in those two areas, we collect the monthly fee for the power from each lot owner of the area.
But once again, the county is guaranteeing it.
Yeah, the county's guaranteeing it.
That would work.
You know.
That fits their criteria of the
But
county.
are
has
the
to
developers willing to make sure and include in their deed restrictions the fact that there's gonna be
Participation mandatory?
mandatory participation in a lighting district?
I don't think they'd have an issue with that.
Because that would be helpful. And also,
But ultimately, the county is going to have to step up and say.
Right, and we do
We
now.
guarantee it, and we're going to get the money out of these folks.
Right, yeah, and we do that now with those areas that we're
Yeah,
doing.
that can work as long as they agree to participate and do participate.
Because one of the biggest problems we had in installing the lights was getting the right-of-way for the light installations after the fact.
Yeah, no, well, after the fact, it'd be difficult, but in future subdivisions, like I said, my developers don't have an objection to putting in the streetlights and paying for them for a year. But after that, somebody else has to pick up the tab.
That's understandable.
Thank you very much.
Jack, you know that we've seen an evolving, and I guess for those of y'all that have been engineers for a long time, you've seen an evolving of infrastructure and in subdivisions. You know, back in the old days, there was no requirements for septic tanks for the there was no requirements for anything. Somebody could go out and buy a lot, build whatever they want. I mean, things have evolved, and they've evolved for the betterment, to protect the consumer ultimately, okay? Whether it's requiring septic tank bonds or sidewalks or lighting, it's all there to protect the consumer. I still haven't heard, unless they're going to come back and give us look, the recommendation should not be we do nothing. That's not the recommendation. Let's just figure out what's going to happen. Somehow we need to ensure that maybe for a subdivision that has X amount of lots on it, they're required to put in sidewalks when the lot is sold. I know you can't control when somebody builds. I know that. But I just don't think that we're leaving it up to us to enforce when the developer, they sell their lot, they make their money, they walk away, and they're done. And now it's up to everybody else to try to foot the bill to make some of these improvements. I think the developer, it's their call, but I think they can, how much of a profit do they want to make? Do they want to make less profit? Do they want to sell their lots? So, I mean, I'm not happy with the non-recommendations that you guys are giving us, because you really haven't given us any recommendations other than what the developers told you what they wanted. That's what I'm hearing. I mean,
Well, I think that we need, I don't know, but I think we need to go back and look at the concentration and the size of the lots.
I agree with
I
that.
think that's a good start.
That I think is an excellent start. Also, if you have curb and gutter, sidewalk is much more viable.
Yes.
So from a developer point of view, it's not cost prohibitive to do curb and gutter in a highly concentrated subdivision.
In a small lot subdivision, no, sir. It's actually cheaper in the long run.
So, I think we
You
need to
just
look
have
at
to
that.
Well, that's what I'm saying, that I think we need to come up with some criteria as size of lots, the number of lots in a subdivision, and you guys need to come up with that. Remember, what we're trying to do is develop something that is not necessarily developer-friendly, but it's more consumer-friendly.
Well, but ultimately, the consumer has to afford the lot.
I understand, and the developer is the one that decides how much of a profit margin they want to make on those lots. Whether it's 20%, 30%, 40%, or 5%. It's their call. It's their call. So where do we go from, where do we go from here? Are you going to come back and
From hearing what's coming to part here.
back on the mic? Back on the mic.
Yes, sir. I think what I'd like to recommend is we table this item for now. We sit down in another workshop with the developers and the engineers. Let's iron out this particular issues that are of concern, and come back with a recommendation that this is what is going to transpire as far as installation of sidewalks.
Okay.
There may be some legal concerns. that
Well,
we
you
need
know
to-
what, get legal involved, but
as far as
coming
where we're
back
gonna
to
put it
us,
at.
as far as coming back to, to me, is not to do nothing.
Correct.
Or you put all the burden on the commission or on Cameron County. The developer's got to do something, and I don't see them giving up anything after y'all's meeting. What did they give up? Really?
They gave up the street lighting infrastructure.
Well, they were already agreed to the
and-
street lighting.
And the maintenance for a year. Yeah, but we gotta make sure that at least we give them credit for that, because,
Yeah, and
that's
I
a big
think
one.
it's a very positive move in that sense, in that utility. I think it's very workable, like the engineer was saying, Jack. We can proceed forward with that, developing policy criteria for it. Continue with that, since we do have a consensus that it can be done, other than who's going to pay for the energy.
Can you tell me what the cost of providing the lights would be?
2,000?
The lights are about $2,000 each. Per light. You put them at each intersection. You need one at an intersection. You need one at the end of a cul-de-sac if you have a cul-de-sac, and then a 600-foot spacing in between. And you're talking about, $300-400 a lot probably.
Okay, and to put in a sidewalk?
Sidewalk's about $1,500 a lot.
Maybe 2,000.
Well, it depends on the width of the lot too.
Well, it depends on the width
And
of
it
the lot.
depends on whether you have curb and gutter.
Well, if you have,
Yeah, so there's a whole lot of variables there.
Take into consideration as well, I mean, look at some of these other rural cross-section areas that do have sidewalks. Look at what's happened there. Because the judge is talking about one that hasn't had issue, but I don't know how that one compares to anything else out there. And then look at do a projection on the cost and maintenance of what it's gonna cost us as a county to maintain these curb and gutter streets and these sidewalks over the lifespan. Because that's something that, I mean, cities have street sweepers, but at the county, I don't know that we have a fleet of street sweepers, and, you know, what that would cost as well.
Well, we would have to develop that because we don't have any criteria to analyze what is going to be the projected cost.
Well, I would
Or
assume
check with
that
cities.
I would assume that the maintenance on a curb and gutter street is less than on a cross-section rural asphalt, right?
Over time.
Over time, yeah, because you don't have anything holding that asphalt together.
And
In
you
curb
could
and gutter, you've got some, you know,
Yeah, you could actually do the maintenance with your current street sweepers that you use for paving, but you're gonna throw the debris up on.
into the
lot.
bar, or onto the bar ditch.
Yeah, but the main thing is that you keep it clean so, you know, trees don't.
Water
grow up.
flows.
Sidewalks, not Wilson Road, Business 83. Textile repaved it, built a beautiful sidewalk adjacent to the curb and gutter. It's blowing out already. There's about 5 sections over there between Harlingen and 800 that are blown out, popped up. So, you know.
All right, so then
that is
you,
a cure.
You know, we haven't even started to talk about some of the calls that we get at my office and possibly some of your offices in regards to handicapped individuals in some of these areas, in trying to access a mailbox or a school bus or whatever. You know, that's a whole other thing that.
Mailboxes, the postal office is now going to the cluster boxes.
Right.
Pretty much everywhere.
Right.
So, yeah, we need to provide access to that.
Yeah, ADA has to be incorporated into that sidewalk system somehow or another because it is required. But you have to have ramps and fixtures like that.
all right, okay, so then you want to come back
If it's all right with the court.
after the 18th, then,
Yeah, that we come back and address those issues and concerns of the sidewalks.
And I have a question too. Right now, do we require concrete driveways?
No, they're not a requirement.
So are we gonna be able to have a sidewalk made out of concrete and then a driveway that's not? Or is that gonna have to be a requirement as well?
That's
Well, we
another
would have
one of
to
the
come-
issues, which is, all right, we build a sidewalk and then you come cut 24 feet of it out to the driveway. What happens there? It gets deleted. That was my fight.
'Cause, I mean,
Most builders do put in the concrete driveways, but it's not a requirement.
In a curb and gutter situation, almost all of them are concrete or at least asphalt. In a rural situation, they're mostly collegiate.
And we do have criteria for that as far as design.
well, keep that into consideration as well, because
So I think that if it's all right with the court, we can go ahead and meet and extend the same invitation again to the developers and the engineers and iron out those.
I still, yeah, I think you need to visit, I think you need to visit with this deposit issue, because that solves that problem part about building the sidewalk where they're gonna put their driveway. You don't build it up. All I'm saying is that developers have to come and, just like they do with the septic tanks, I don't see why they cannot come up with a letter of credit to ensure the building of a sidewalk. And maybe you could tie it into once 80 or 90% of the subdivision is complete. There's gotta be something.
The only thing about that is that there is no a state statute that you can use to enforce it. We can develop an order and the court can consider.
Well, we don't have to apply, you know, we don't have to approve subdivision plats if they don't have that.
can we deny
I don't
the
know.
approval? I don't
That's
think
a
we
legal
can.
question that needs to be in, you know, because unfortunately in the state of Texas, counties only have the authority the legislature gives you. Have they given you that authority?
I don't know.
I don't know either.
The health and safety of the public.
No, I'm not talking about the sidewalks. I'm talking about having them put a deposit, like a letter of credit to build the sidewalk as part of, you know, just like we did when we had the flooding issue. And I said, look, I mean, what we were doing at the time was just making sure the water went out of the subdivision. We didn't follow it to see where it ended up, so it was always ending up in somebody else's subdivision. Remember that? Commissioner Tamayo was on
Mariposa Ranch.
on the commission. And so we decided from now on, it's not just getting the water off of that subdivision. Where does it ultimately end up, so it doesn't end up in somebody else's backyard? So I think we can do that. But anyway, Let me have a motion to table it and then just put it back on the agenda when you're ready.
So moved.
Moved by Commissioner Gatsa, second by Commissioner Sanchez. All in favor, signify by saying aye.
Aye.
Any opposed, item carries. Jax, good to see you. Take care of yourself. Item G, consideration approval of reclass and salary adjustment of human resources. Arnold, that's
Yeah, that
you.
would be reclassifying and adjusting the salary for the Human Resources Law Enforcement Coordinator to Administrative Assistant to Administrative Services Director.
Who's going to be taking over the law enforcement side of what they were doing?
Right now, I worked that out with they were doing the background checks. That's what Mr. Frizzell would do. I worked that out with emergency management, and they've been doing those background checks for us, and I checked with Susie, and that's been working just fine.
Working okay? All right. Do I hear a motion to approve?
At a savings of how much?
A little over $7,000.
Second.
Moved by Commissioner Benavides, second by Commissioner Gatsa. All in favor, signify by saying aye.
Aye.
Any opposed, item carries. On item H and I, we discuss after executive session. Item J has been discussed. Item K, discussion and possible action on whether to allow an employee to stay in the manager's residence at Adolph Tomei Park. Javier, what's all that about?
Judge, Commissioners, what this is that the manager from Adolph Tomei Park, he bought a home in Brownsville. So he's staying in Brownsville. He's not staying in the residence anymore. So one of the employees that works for us there at Tomei is interested in staying at the residence. The thing is that in his job description for the manager, we did specify that he had to reside on premises. So talking to
Okay,
Bill-
hold on.
Yes.
You have the manager that's there now, that used to live there.
Right.
And that was one of the requirements.
Right.
So he's left to build,
So he resigned by leaving?
He bought a home in Brownsville because it was difficult for his...
he's still the manager though, right?
Yes, he's still the manager.
Okay, so then if that was one of the requirements to be the manager, to live on premises, so what does this do now in terms of him living in Brownsville?
His employment.
Yeah, I mean, what happened? I mean, that was one of the requirements that he do that. So has he resigned as the manager?
No, it wasn't, I guess it was a requirement we did after we hired him because before we had contracts with the managers that stayed at Andy Bowie and Adolph Tomei. But he bought a home in Brownsville and now he's not living there. I mean, if that's the situation where he has to resign because of that, then, you know, we'd have to deal with that.
Do we provide him a vehicle, and is he going to be going back and
No.
forth to Brownsville now?
No.
Okay.
Well, I mean, what are you recommending?
I would think, you know, from my perspective, and I've been there a lot lately, I think we need somebody there living there. I think it's helpful to the park. It's helpful for, you know, obvious reasons.
agree.
That having a presence there is important. I think that.
Are they on call 24/7 or?
They're not, but you knock on the door, they,
Yeah.
you know.
And that was one of the requirements is that, you know, if it was after hours, if they needed something, then they would go to the...
Respond.
What is the rent on that place?
It's $150.
How much was he paying rent?
$150.
$150 a month.
And what's
Is
the
it one-
average?
Is it 2 units or 1 unit? I mean, it's like separated in two, right?
Right. The other one is there is a second unit there.
So
It's a one-bedroom with a kitchen and a bath.
So there's 2 units.
Right.
So technically, we could offer 2 people to utilize that area,
Right.
okay? And which might not be a bad idea of their employees, because, you know, the presence there makes a big difference for that part of
Oh, no,
someone.
there's no doubt. No doubt.
But there's no requirement that they actually be there certain hours, right? After hours, they have to go run errands or go grocery shopping or whatever.
They do their
It's
work.
okay.
They're 40 hours, and that's.
Okay.
So are they on, I missed, I'm sorry, I was out. Are they on salary during the day?
Yes.
Are they required to be there?
40-hour
during-
week.
Are they required to be there?
40-hour week. They work a 40-hour week.
Right, they're salary employees.
I have something, I don't want to say it publicly, I'll tell you privately.
No, but this is the time we need to.
Well, I think, you know, the concern I've heard is that there's private fishing charters and things that go on during the day, that these people are doing this. The people, I don't even know the name of the person, I don't know who it is, but they're doing this on the 40-hour county time. And so I don't know if that's proper or not.
The guy that works there?
I don't know. I don't know. All I'm telling you what I've heard. I don't know if it's a fact
Yeah.
or not.
Well, I've heard that Javier Mendez has a fishing charter service operating out of there too.
Oh, do
And
you?
I asked him yesterday, and he says he wishes, but he doesn't. I've heard that, other people have fishing charters. I know that on occasion, when allegations have been made about that occurring, you've checked them out.
Yes.
And according to the timesheets and who's supposed to be there when, that's not been the case. There's, I had one gentleman yesterday in regards to this item that came to my office, and he was totally upset about the whole Tame Park, about, the issue of we're trying to get a lease for 25 more years. Because according to him, we're the worst stewards of property that there are anywhere. At the same time, Javier shared a video that he had of volunteers cleaning the opposite side of the arroyo, bringing the trash and unloading it by the county park area to put in the bins. And the video they sent him was saying how people were dumping at the county park, not knowing that there were actually a group of volunteers using their own personal boats to do a cleanup on the other side. So the stories are like crazy, People say things when they only see a very little narrow gap of what's occurring.
All I'm telling you is what I was told. I do
Yeah.
not know if it's fact. I don't want to sit here and say, yes, it's true.
But
I
we
don't
checked-
know.
It was checked out,
Okay.
because some of us got that same complaint.
Okay.
I still say we need to have somebody living on premises. It makes a huge difference for everybody there, having like eyes. People never know when somebody's around and looking and seeing, because we're not there 24/7.
Could I ask just one question? Did the manager pay rent?
Yes.
Okay, and he's now gone, he's not paying rent anymore?
Right.
And you're talking about letting a new employee pay that rent?
Correct.
Okay.
Would we have to pay that new employee if he's not on salary overtime whenever he's called out, or would that be part of his supplemental pay by getting to live there at a reduced rate?
That's it.
To me, if that's the case, if that employee's gonna take over the responsibilities that the manager had in terms of being available, I don't see what the big deal is. I say we approve it.
Yeah, I would just have to change his job description and require him to have the same responsibilities.
Okay, we'll bring it back to the next meeting, and, because it's like Commissioner Garza says, we need somebody there. If the manager, maybe because he has a larger family or whatever, needs more space, and went and bought a house somewhere else, I can understand why you'd want to do that. But as long as we're getting what we need done, and it's not costing us more money, I don't see why we would want to oppose it.
It's the same thing as the current at Andy Bowie, right?
That's correct.
Same thing.
And if you start a fishing guide service, we need to know.
Let us know.
You mean letting us know again? All right.
I would recommend that the court, if they're going to approve that, to approve it subject to negotiating a lease agreement with this individual, so that the county will have the reinforcement to collect the rent.
Where was the employee living before?
Brownsville.
So now he's moving, basically, or?
Oh, you're talking about the one that wants to move in
The
there?
new one, yeah.
He lives in Harlingen.
Okay, and he's gonna leave wherever he's at and go live over here?
And live
It's a
over
lot
here.
easier to not have to commute that far.
Yeah, no, I agree. All right, okay. So what do y'all want to do?
Can we approve it subject to legal working out an agreement?
Move to approve subject to legal working out a lease agreement and and changing the job description on the new individual to accept the duties.
And the manager.
And changing the job description of the manager not to require him to live there anymore, as long as one of the employees does live there.
Second.
Moved by Commissioner Sanchez, second by Commissioner Gatsa. All in favor, signify by saying aye.
Aye.
Any opposed? Carries. Item L, discussion and possible action to allow the Cameron County Parks and Recreation Department to solicit invitation to bids for possible land lease.
Judge, Commissioners,
Is there an executive session item on that? No? Okay.
we had an interested party that was wanting to put a wind measuring devices at the flats at Andy Bowie. So we prepared a draft invitation to bid. They're interested in using it for 2 years. We brought this to the court, see if the court was interested in allowing us to go out for bids.
How tall is that thing?
I don't know the height of it.
497 feet. That's the height of the wind farms.
Is that how high one of these things is?
How much are they?
I'm not sure.
497.
The
So
height.
we're thinking about allowing someone to put up I guess, a big wind measurement device out in the flats, in the middle of nowhere, just out there sticking up like a sore thumb.
Gives the place some character.
I mean, I'm not sure if y'all are interested in doing that.
Why don't they go to private property?
I think, I mean, they could, they just need to locate, need to find a place that's.
I think
close.
aesthetically, I mean, it just doesn't look, I mean, it's right across from the shores and all those other, right across, I mean.
Well, that'd be a good parking lot for Clayton to park all kinds of people over there, right? The flats.
That's where they need
And
to
they
go.
could.
Because you can park there and still see the fireworks, right?
That's where they need to go.
I just don't know if that's where we want to go. I mean,
Okay.
putting something up like that in the middle of the flats, the middle of the island like that, just aesthetically, just doesn't appeal to me unless it does to you guys. Doesn't appeal to me at all.
Unless it's going to be like an observation deck for SpaceX, then
Well, if
probably
there were,
not.
if
No,
there were no private property there, I could see it, but I mean, there's a lot of private property.
And that's where they do the kite flying thing, don't they?
Yeah.
What they're wanting to do is in preparation of the wind farms offshore, they need it for two years to be able to collect some of this data.
And they can't put it at the top of one of the tall buildings on the island?
I'm not sure what research they've done.
Doesn't the Coast Guard have like a tower also over there?
On the south end.
Top of the causeway?
Couldn't they get a private property owner that's further north on the island, maybe right on the Willacy County line, that they can somehow lease
Doyle
from
Wells.
them or something? I just don't think it'd be a good idea to have it that close in. No, I don't want to table it, I want to just deny it. I guess we could table it forever, but, send them that we can't. I mean, I don't think we should.
Move the table.
Moved by
Second.
Commissioner Gatsa, second by Commissioner Sanchez to table. All in favor, signify by saying aye.
Aye.
Any opposed, item carries. And Javier, if they need your help, maybe to contact some of the property owners of the way north and work something out with them. I mean, there's nothing out there.
Right.
All right?
Okay.
Thank you. Item M, discussion and possible action on the concession terms for a Cameron County Native Plant Center related to temporary housing on the premises.
This is, Dilby is working on a lease agreement with Thor Lassen for the Native Plant Center. And one of the things that Thor was requesting was to allow internships to be able to stay on premises during, their studies. And Dilby wanted me to put this on to see if we wanted to allow that, so she can insert that in her agreement.
When you talk about staying, what does that mean? Like camping out or what?
Well, no, they would have a residence.
They'd be kind of like the park thing, where they'd be an apartment or a room with a.
But there's nothing there now, is there?
No, but in the architectural
To build
process,
something.
in the build process, they're looking at incorporating that, just like Sea Turtle Link is doing the same thing. They have these interns coming in from the university.
I don't think that's a big deal.
Like a caretaker home type?
Yeah.
Something like that.
I don't think I think that's okay. I mean,
Well, and a lot of. Right, and a lot of some of the interns, we have like the Sea Turtle Link people now
Efficiency apartment type.
are in FEMA trailers at Andy Bowie Park.
all right, y'all have any problem with that? No?
Move to
Motion to
approve.
approve
Second.
by Commissioner Sanchez, second by Commissioner Gatz, all in favor, signify by saying aye.
Aye.
Any opposed, item carries. We have a supplemental, it's one action item that we will discuss after executive session along with the other ones. Do I hear a motion to go into executive session? So moved. By Commissioner Hernandez, second by Commissioner Benavides. All in favor, signify by saying aye. Any opposed, item carries. To discuss the following items related to pursuant to Code Section 551.072, 551.0712, and 551.087, 551.0712, 551.072 and 551.0712, 551.087 and 551.0712, 551.011A and 2, and 551.072. We'll be back.